fact been served. The depositions by Mr. Aluocher in his affidavit sworn on 16th January 2021, filed in hearing, are matters that should have been presented before the High Court in order to satisfy itself that the President was duly served. In paragraph 537 of the judgment, the High Court observes that the President did not enter appearance in these proceedings, and neither did he file any grounds of objection or replying affidavit to contest these proceedings on the ground of misjoinder or any other ground. However, there is no indication that the High Court satisfied itself that service had been effected. Indeed, in the same paragraph of the High Court judgment, the court stated, quote, "As much as the Honorable Attorney General has come to his defense, the grounds of objection and submissions filed by the Honorable Attorney General are clearly stated to have been filed on behalf of the Attorney General himself and not for Mr. Uhuru Muigai Kenyatta," end of quote. An acknowledgement, in my view, that the proceedings against the President were undefended. Having concluded that the Attorney General could not in this instance represent the President, it was imperative for the court to satisfy itself that the President had been served with the petition and the hearing notice. It is also noteworthy that although the High Court expressed in paragraph 532 of its judgment that the question whether the President can be sued in his personal capacity and not as the President of the Republic is a question that, quote, should be determined as a preliminary issue, quote, it was not in fact handled in that manner. For had it been handled in such manner, the determination should have been made before the substantive hearing of the petition commenced to afford the President an opportunity to defend himself in his personal capacity. By making the determination in the final judgment, that opportunity was lost. All in all, I am not persuaded that it was satisfactorily demonstrated that service on the President was effected, and for that reason alone, I would set aside the orders made by the High Court against the President in Petition 426 of 2020. On the presidential immunity question, I have indicated that I sat in the judgment of this court in Kenya Human Rights Commission and another versus Attorney General, and my views have not changed that the decision of the High Court is right in that regard. I still hold, therefore, and agree with the pronouncement by the High Court in the present case that the President can be sued in his personal capacity during his tenure because the protection afforded under Article 143(3) of the Constitution extends, quote, anything done or not done in the exercise of his power under the Constitution. On the issue of the amicus curiae, I have referred to the Supreme Court decision of Trusted Society of Human Rights and the extensive guidelines that were given there, and I have concluded that it was not demonstrated that the High Court exercised its discretion wrongly in admitting the amici. On the issue of justiciability, I have said that the matter was ripe and that it was not prudent for anybody to wait until the provisions became the Constitution and then have to contend with Article 2(3) of the Constitution, which prohibits any challenges to the Constitution. So with that, I will end it there and hand it over back to the President. Thank you.
Thank you very much, my brother Justice Gatembu. It is now 1:40. We shall adjourn for 1 hour, and so we will be back at 2:40. The court will adjourn.
that the power to make such change rests elsewhere in the primary constituent power of the people and need not be codified. Let me then turn on what constitutes basic structure of our Constitution. This is what the High Court rendered itself. And I read, while the basic structure cannot be altered, I think I'll skip that, but just emphasize that there was a controversy on their finding that whether a particular clause in a constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution. That is what I turn to interrogate. The appellants criticize the findings and argue that the High Court failed to identify the said clauses and provide any objective criteria for such identification. It is submitted that in the absence of clarity, no amendment could be effected without first seeking the court's interpretation, clarification, and concurrence on which provisions are amendable. Thus, therefore, this therefore will be left to the subjective opinions of the individual judges. A common thread running through the Bomas draft constitution, the WACO draft constitution, the revised harmonized draft, and the proposed draft constitution is the provision for amendment of the constitution by popular initiative. The rationale for this amendment process, captured in the final report of the recommendations by the CKRC report, as regards the issue of constitutional supremacy, was that the new constitution should have some entrenched provisions which Parliament would have power to amend without first seeking the views of the people at referendum. Under the scheme of the various constitutional proposals, a distinction was drawn between entrenched and non-entrenched provisions of the Constitution. The entrenched provisions are those that the people felt were the core values and provisions of the Constitution and therefore needed to be barricaded by a special amendment mechanism in which the seal of approval by people exercising their constituent power was mandatory. Notably, the entrenched provisions in the various drafts were substantially the same. In the Bomas draft, they were in respect to the supremacy of the Constitution, the territory of Kenya, the sovereignty of the people, the principles and values of the Republic, the Bills of Rights, the term of the office of the President, the independence of the judiciary and constitutional commissions, the functions of Parliament, the values and principles of devolution, and the provisions of the amending chapter. The WACO draft retained the same list, save for a small change in regard to the devolution. The entrenched provisions in the latter harmonized draft and the revised harmonized draft are almost forward those in the Bomas and WACO drafts. They again found their way into the protective provisions of Article 255(1) of the 2010 Constitution. It is a list that survived changes made in the various draft constitutions. It is testimony that the people meant what they said and were clear as to what they considered to be the essential features of the Constitution. It is a list to be revered and cannot be lengthened by judicial interpretation or craft. It matters not if Kenya felt so strongly that the provisions relating to the matters listed in Clause 255(1) needed protection from indiscriminate amendment, then even more so, those are the very provisions which should not be abrogated or replaced without the exercise of the people's constituent power. In my view, what comprises the basic structure of the Constitution is therefore specifically defined by the people of Kenya, and there are those in Article 255(1) which even in amendment require the exercise of constituent power, and that is the secondary power, constituent power. That said, the true concept of the basic structure in the Kenyan Constitution becomes clearer still by looking more closely at the words of Article 255(1). They require compliance of Article 257 for an amendment that relates to the matters listed in Article 255(1). Save for reference to Chapter 16 and Articles 10, the articles of the Constitution to be protected are not specifically set out. Instead, they are identified by theme. And this makes a difference. What comprises the basic structure is what is in respect to those thematic matters. So, for example, matters on the sovereignty of the people, which power, by dint of Article 3, is delegated to the three distinct arms of government, extends the protection to the doctrine of separation of power. So, while the doctrine of separation of power is not directly mentioned in Article 255(1), it is part of the basic structure of our Constitution, as it is a subset of the wider design on how the Constitution has organized and structured the exercise of sovereign power. I take a view that what comprises the basic structure of our Constitution is therefore easily identifiable. But should a need for judicial inquiry arise as to whether a matter is part of the basic structure of our Constitution, then that inquiry will not be rudderless, neither will it be an unguided exercise, because it is firmly beaconed in Article 255(1). So those are my short views on the question of the basic structure and its breadth. I then turn to the question of the IEBC quorum. In deference to Section 8 of the IEBC Act, the second schedule to the Act makes provisions as to the conduct of the business and affairs of the Commission. The schedule underwent some amendments through Act Number 1 of 2017. In respect to the quorum of the Commission, the amendment reduced it from 5 to 3 in the following words: the quorum for the conduct of the business at the meeting of the Commission shall be at least half of the existing members of the Commission, provided that the quorum shall not be less than 3 members. The amendment was not without controversy and was the subject of a constitutional challenge in Katiba Institute and 3 others versus the Attorney General. In a decision rendered on the 6th of April 2018, Muita J declared the new provision unconstitutional. In the impugned judgment, the High Court judges proceed on the assumption that the latter provision requiring a quorum of not less than 5 was the existing provision. The judges do so without ambiguity in paragraph 702 of their decision, which I have set out. The argument by IEBC is that while the decision in Katiba had the effect of declaring the new paragraph 5 of the second schedule unconstitutional, the decision did not revive the older provision, and so, as it now stands, there is no statutory provision on the quorum of the Commission. What would be the legal effect of the above declaration? Cited by IEBC is the decision of the Supreme Court in Mary Wambui versus Gishuki Kingara, in which the court had occasion to consider the effect of a court's declaration of invalidity of a statute or provision within it. I have set out what the Supreme Court said. Clearly, the true effect of such a declaration can only be gleaned from the declaration itself. The court may make the declaration retrospective from the date of enactment of the offending provisions or statute. The court may choose to limit the retrospective effect of such declaration or even to suspend it to a future date. And as held by the Supreme Court in Mary Wambui, the effect ought to be retroactive and or proactive depends on a case-to-case basis. So, for example, in petition number 413 of 2016, Boniface Oduor versus the Attorney General, the High Court, after declaring sections 33B1 and 33B2 of the Banking Act to be constitutional, suspended the declaration for 12 months from the date of the decision. Where, however, a declaration by the court is silent as to when it shall take effect, the date of the declaration is deemed to be the date of effect. In Katiba Institute, Justice Muita declared paragraph 5 of the second schedule, amongst other provisions, to be constitutionally invalid without more. The judge neither limited the retrospective effect of the declaration nor suspended it. To be inferred, therefore, is that the declaration operated retrospectively to the date of the enactment of the provision. The repercussion declaration was that the amendment of paragraph 5 of the second schedule to the Act, which was introduced by the Elections Laws Amendment Act number 34 of 27, was constitutionally void. Under the Interpretation and General Provisions Act, to amend means to repeal, revoke, rescind, cancel, replace, add to, or vary, or the doing of any two or more of those things simultaneously on the same written law or instrument. Amendment of a statute is a legislative act, and while it is open to a court to declare an amendment to be constitutionally void, the declaration does not revive the former provision, just as it does not repeal or annul a provision it has declared to be constitutionally invalid. The former provision would have to be revived by legislation, a preserve of the lawmaking body. And in this regard, I have quoted a Supreme Court decision from India. And although not having a direct bearing to the matter at hand, one would perhaps draw parallels from Section 20 of the Interpretation and General Provisions Act. So, in my view, revival of a previous provision of statute has to be the work of legislative craft and cannot be implied or derived from the judicial pronouncement of the unconstitutionality of the amending provision. And let me explain why I am attracted to this proposition. Take an instance where a declaration of an invalidity of an amendment by the High Court is not challenged on appeal. If it were to be construed that the court's pronouncement amounts to automatically reviving the amended provision, then even courts of a higher rank will be bound by that revival, notwithstanding that such a court would be of a view that the declaration was made.
Of the basic structure in Kenya. On the other hand, the respondents opposed to the appeal came out in equal measure in support of the findings of the High Court. Both sides of the divide relied on scholarly writings, decided cases in Kenya and elsewhere, as well as the history, text, and context of the 2010 Constitution. It is noteworthy to point out that the scholars themselves were not in agreement on the applicability of the doctrine. Professor Migai Akech and Professor Charles Manga Fombard supported the notion of non-applicability of the basic structure doctrine in Kenya, whilst Dr. Ojwang, Dr. Linda Musumba, and Dr. Osogo supported the notion of the applicability of the basic structure doctrine. Be that as it may, the respondents opposing the appeal expressed fear that if the legislator is left unchecked the 2010 Constitution may be dismembered and mutilated to the extent of it of a constitution. No doubt, the respondents' deep-rooted fear is informed by the history of lack of constitutionalism in Kenya. It is for this reason that the respondents opposed to the appeal urged us to find that the basic structure doctrine is rooted in Kenya's history, text, and experience, as well as comparative constitutional theory in the form of decided cases and scholarly works. It was their argument that the courts must reconcile contradictions, draftsmanship gaps, vagueness, and phraseology in the Constitution and arrive at the conclusion that the basic structure doctrine is applicable in Kenya for the safety of the 2010 Constitution. In support of their contention, they relied on several authorities which are set out in my judgment, and in the intro, I shall not go through all of them. The ones that I brought on board into my judgment include in the matter of the Speaker of the Senate and Mother Kerubo Moacha versus Nairobi, in the Commission for the Implementation of the Constitution versus the National Assembly, where Lenaola J, as he then was, held that where the basic structure or design and architecture of our Constitution are under threat, the court can genuinely intervene and protect the Constitution, end of quote. They also relied on the decision of Jasbir Singh, and as I've said, they also relied on scholarly works, in particular the works of Professor Dietrich Conrad, writing on implied limitations. In support of the contention that the Constitution also has the unspoken language, they placed reliance on scholarly writings of Yaniv Rosnai, constitutional amendments, the limits of amendment powers, where he states, and I quote, "In order to find an amendable basic principles, one has to resort to interpretation of the Constitution as a coherent whole. It is, after all, a constitution and not just a disjointed collection of constitutional pieces which must be interpreted. According to this approach, the language of the Constitution is not merely the explicit one, but the implicit one." The respondents opposed to the appeal argued that notwithstanding the fact that the 2010 Constitution does not expressly bar amendments, it does so implicitly, as one has to pay attention to its overarching themes and/or the spirit of the Constitution. Heavy reliance was also placed on the Indian Supreme Court decision of Kesavananda, and in this Kesavananda decision, by a majority of 7-6, it was held that there are some provision in the Indian Constitution that form the basic structure of a constitution and hence are not amendable, not even when the prescribed procedures are adhered to. On the other hand, the appellants and the respondents in support of the appeal were clear. The basic structure doctrine is not applicable in Kenya. They urged us to find that the 2010 Constitution has sufficient safeguards that militate against hyper-amendments of yesteryears. The appellants and the respondents supporting the appeal also sought to rely on case law, decided cases, the history, text, and context of the 2010 Constitution. These included in the Council of Governors versus the Attorney General, where the Supreme Court stated as follows, Courts may not impose a meaning that the text is not reasonable. In other words, interpretation should not be unduly strained. It should avoid excessive peering at the language to be interpreted, end of quote. On the invocation of the spirit of the Constitution, reliance was placed on a decision of South Africa in the decision of the Premier of KwaZulu-Natal versus the President of South Africa, where the Constitutional Court held that, and I quote, "The reliance upon the spirit of the Constitution is, in my view, misconceived. There is a procedure which is prescribed for amendments to the Constitution, and this procedure has to be followed. If that is properly done, the amendment is constitutionally unassailable," end of quote. Back home, the appellants and the respondents in support of the appeal also relied on the decision of Jasbir Singh Rai. They also cited the decision of the Speaker of the Senate and another, and also the decision of the Attorney General and another versus Randu Zai Rua, wherein these courts acknowledge that the people may amend the 2010 Constitution by a referendum to alter the territory of Kenya. That is to give effect to secession. They also cited the decision of the Senate and 48 others versus the Council of County Governors and 54 others. Then there is also the decision of Titus Alila and 2 others, where Fred Ochieng judge acknowledged the fact that our Constitution does indeed make provision for the amendment of the Constitution. In my view, the above decisions underscore the fact that the 2010 Constitution is amendable, subject to the process and methodology of amendment set out in Articles 255 to 257 of the Constitution being adhered to. As regards jurisprudence from foreign lands, decisions from Malaysia, from Singapore, there were also decisions from Uganda, from Zambia and Tanzania, wherein the appellants and the respondents in support of the appeal relied on, and all these decisions of the basic structure doctrine. In particular, I wish to read some part of the decision in the matter of Paul K. Semogerere and others versus the AG. This is a decision from Uganda wherein they discounted the Kesavananda decision, and this is what they said. Those who framed the Constitution also know that new and unforeseen problems may emerge. That problems once considered important may lose their importance because priorities have changed. The solutions to problems once considered right and inevitable are shown to be wrong or to require considerable modification. That judicial interpretation may rob certain provisions of their intended effect. That public opinion may shift from one philosophy of government to another. The framers of the Constitution did not put any limitations on the amending power because the end of a Constitution is the safety, the greatness, and the well-being of the people. Changes in the Constitution serve these great ends and carry out the real purpose of the Constitution. There is also the other decision from Uganda, Male Mabarizi and others, which of course also discounted the doctrine of basic structure. So in my view, the above decisions from Malaysia, Singapore, Zambia, Uganda, and Tanzania demonstrate that the courts have rejected the doctrine of basic structure on the reasoning that a constitution, being a living document, must inevitably change as society progresses. That a living constitution must be flexible to allow for a country's growth and the review of our Constitution is essential so as to cater for new and unforeseen future problems, and hence it is inadvisable to have a Constitution cast in stone. To my mind, I have no illusion whatsoever that the Kenya's constitutional past was indeed a dark past. The pre-2010 Constitution was misused and abused for selfish political gains. Several instances stand out. In 1974, Paul Ngei, the then minister in the late President Kenyatta's government, was found guilty of an election offense and by operations of the law was barred from running in the ensuing by-election. To save him, His Excellency, the late President Kenyatta, passed into law a bill tabled in Parliament and passed into law in a single afternoon, pardoning Honorable Paul Ngei of an election offense. 1982 constitutional amendment that dealt a blow to multi-party democracy and turned Kenya into a de jure single-party state of the then all-powerful Kenya National Union. The reason for the hastily carried out amendments or of the pre-2010 Constitution are not difficult to discern. The power to amend the Constitution was provided in Section 47 of the pre-2010 Constitution, and this power was reposed solely in Parliament to the exclusion of the proverbial Wanjiku. I have cited the provisions of Section 47 of the 2010 Constitution. Our pre-2010 Constitution, like the Indian Constitution, did not bar amendability. It is against the backdrop of the Indian Constitution, where there is no provision for amendment of the Constitution by the constituent power, but the power to amend being reposed solely in Parliament, that the Casavananda decision was made. In his scholarly writings, Yaniv Rosnai traces the history of the basic structure doctrine and how it was developed in response to Prime Minister Indira Gandhi's attempt to amend the Constitution. He states, "The Indian Constitution lacks any unamendable provisions. Also, Indian jurisprudence, rooted in British tradition, initially rejected the notion of implicit unamendability. That position, however, was revised in the 1960s and 1970s, following Prime Minister Indira Gandhi's far-reaching attempt to amend the Constitution, leading eventually to the judicial development of the basic structure doctrine. According to this doctrine, the amendment power is not unlimited. Rather, it does not include the power to abrogate or change the identity of the Constitution or its basic structure," end of quotes. Yaniv Rosnai provides a further criticism of the Kesavananda case for failure to identify the unamendable clauses. He writes, "The Kesavananda case did not provide a precise list of unamendable features that constituted the Constitution's basic structure, thus forming a sort of common law doctrine that develops on a case-by-case basis." And he further stated that the Kesavananda judgment created a constitutional quicksand. In his written submissions, Professor Charles Manga Foreman, an amicus curiae on the basic structure doctrine, outlines the essence of this, what he refers to as the much acclaimed Indian basic structure. And he states, "The much acclaimed Indian basic structure doctrine owes its origin to the famous Supreme Court decision in Kesavananda decision, although the issue had been raised in a number of earlier cases. According to this doctrine, even in the absence of explicit limitation on amendment powers, Parliament's amendment powers are not unlimited. There are, as a result, implied constitutional limitations that render an amendment unconstitutional if it infringes, negates, or substitutes the basic structure of the Constitution, regardless of whether all the formal or procedural requirements of amendment have been met." End of quote. Professor Foreman points out that when the doctrine of basic structure was developed, India was dealing with, and I quote, India's 20th century independence constitution of the 1950s, whereas African courts are now dealing with made-in-Africa constitutions of the 21st century, end of quote. And that due to the change circumstances, the Kesavananda decision is not relevant to our circumstances. This court has had occasion to express its reservations in adopting foreign concepts to our homegrown constitution. And I cite the case of Kenya Airports Authority versus Mitubel Welfare Society, where this court stated as follows: whereas citation and reliance on persuasive foreign jurisprudence is valuable, foreign experiences, values, and aspirations of other countries should rarely be invoked in interpreting the Kenyan Constitution. The progressive needs of the Kenyan Constitution are different from those of other countries. In my view, the position obtaining in India, insofar as it related to its constitution, was not any different from the position obtaining in Kenya before the promulgation of the 2010 Constitution on 27th of August 2010. The Indian Parliament has the exclusive power to amend the Constitution. Our Parliament has similar power to amend the Constitution prior to the 2010 Constitution. The situation obtaining in Kenya after the promulgation of the 2010 Constitution is different. There are explicit provisions on the amendments of the Constitution, as well as inbuilt mechanisms which limit Parliament in amending the Constitution. The methodology to amend the entrenched provisions is also clearly spelled out. There are also clearly spelled out entrenched provisions. Suffice to state that the Constitution itself anticipated that it can be amended, and it provided for its own amendment procedures. In the same Constitution, there are strictures as regard entrenched provisions which require a referendum and which ones do not. These are listed in Article 255, 1, Subarticle A to J, and I shall not go through them. The High Court, in the impugned judgment, appreciated as much, and that part of its judgment is stated. To be sure, there is no clause in the Constitution that explicitly makes any article in the Constitution unamendable. However, the scheme of the Constitution, coupled with its history, structure, and nature, creates an ineluctable and unmistakable conclusion that the power to amend the Constitution is substantively limited. The structure and history of this Constitution makes it plain that it was the desire of Kenyans to barricade it against destruction by political and other elites. As has been said before, the Kenyan Constitution was one in which the Kenyans bequeathed themselves in spite of and at times against the political and other elites. Kenyans therefore were keen to ensure that their bequests to themselves would not be abrogated through either incompatible interpretation, technical subterfuge, or by the power of amendment unleashed by stealth, end of quote. In my view, whereas the High Court correctly found that there are no explicit provisions in the 2010 Constitution barring amendments, the judges erred in finding that the bar to amendment is implicit. As stated above, the pre-2010 Constitution did not have provision for the amendment of the Constitution by way of a popular initiative, and neither did Parliament recognize the notion of implicit unamendability. In essence, the Attorney General was whether the Parliament could, in the exercise of its amendment power under Section 47 of the Constitution, repeal the Constitution. I have cited a passage from that decision of Njoya decision that is relevant to this judgment. It is the Njoya decision that paved the way for the amendment of the pre-2010 Constitution by constituent power via a referendum. This was in recognition of the supremacy of the sovereignty of the people, who then exercised that sovereignty in the referendum that birthed the 2010 Constitution. In my view, the Njoya decision was our Kesavananda moment, and to paraphrase Yaniv Rosnai, this may have been as a result of the late President Kenyatta's and the late President Moi's far-reaching attempts to amend the Constitution, and there was need to curb those excesses. As history will attest, the clamor for a new constitution was long and arduous. But that notwithstanding, when the Kenyan people finally bequeathed themselves with a new constitution, they ensured that it would be free from hyper amendments. Indeed, the 2010 constitution was informed by Kenya's dark past, and its citizenry were determined never again shall we have a constitution that can be amended at will. In the formulation of the 2010 constitution, a conscious effort was made to ensure that we do not have hyper amendments. This conclusion is supported by findings contained in the final report of the Constitution of Kenya Review Commission, CKRC, which mirror Chapter 16 of our Constitution. I've reproduced part of the reports of CKRC that mirror Chapter 16 of our Constitution. Following the recommendations of CKRC and true to word, Chapter 16 of the 2010 Constitution is dedicated to amendment of the Constitution. In my view, the clear text and language of Chapter 16 is that there are explicit provisions in the 2010 Constitution providing for amendment, and therefore there is no reason to look outside the Constitution and import the basic structure doctrine on the basis that the Constitution has the unspoken language and or implicit provisions. And it has now been slightly more than 10 years since the Constitution was promulgated, and to the credit of the drafters of the Constitution, the 21 attempts to amend the Constitution, 19 were through a parliamentary initiative, whilst 2 were through a popular initiative, have all fallen by the wayside. These 21 attempts are tabulated in the written submissions of Mr. Ogeto, the Solicitor General appearing for the Honorable Attorney General. I have also reproduced those 21 attempts in part of this, my judgment. It is also true that the framers of our Constitution balance between flexibility and rigidity. To this end, CKRC had recommended, and I quote, that there is need to protect the Constitution against indiscriminate amendments. If the amendment procedure is too simple, it reduces public confidence in the Constitution. True. If the amendment procedure is too rigid, it may encourage revolution instead of using the acceptable constitutional means. Thus, a balance must be struck between these two extremes: violent revolutions against abusive amendments. In an article, The Politics of Constitutional Change in Kenya Since Independence, 1963 to 1969, Professor Okoth Ogendo underscores the fate of post-independence constitutions. He writes, "Constitutional systems in Anglophone Africa have not had a happy history, especially during the last decade. Almost without exception, the independence documents have either ended up in military dustbins or have undergone change so profound and rapid as to alter their value, content, and significance beyond recognizance." End of quote. I hear the good professor saying the Independence Constitution was so badly dismembered, and that if they did not suffer the fate of dismemberment, it was more likely that the Constitution would find their way into dustbins following military coups. The writings of Professor Okoth Ogendo echo the profound words of John F. Kennedy in 1962 when he stated, and I quote, "Those who make peaceful revolution impossible will make violent revolution inevitable." End of quote. It is no secret that the framers of our 2010 Constitution struck a balance between stability and instability by providing for amendments in Chapter 16 of the 2010 Constitution, and this being the supreme law of the land, it was desirable to give it a more stable character and free it from hyper-amendments. This is important as no society is static, and what is good for one generation may not necessarily be good for the next. In an article entitled "No Generation Has the Right to Impose Its Own Values and Political Principles on a Later Generation" by Professor Forman, he cites another scholar, Colvin De Silva, who states as follows: "Constitutions are made in terms of the stage of development at which any given society or country has arrived. In terms of that stage of development, it looks upon things, and for any generation of people to imagine that it can so completely project itself into infinity of the future, so as to be able to decide its own generation that it will constrain a future generation or generations forever within the confines of its own postulates, is to make a mistake of thinking that any human collectivity is the equivalent of the divinity." End of quote. He concludes, "It is unlikely that the framers of the new or revised African constitutions wanted to prevent future generations from repealing these constitutions. A constituent body is omnipotent only to the extent that it has no power to destroy or limit the omnipotence of a future constituent body. In short, the present and future generations should not be ruled by the dead hand of their ancestors." End of quote. It behooves us to recognize that in spite of the supremacy of constitutions, we cannot and should never legislate from the graves, what Professor Forman refers to as the dead hand. We cannot possibly shackle future generations by what we consider to be noble today. The other troubling aspect of the impugned judgment is that the High Court came to the conclusion that whatever is amendable will be decided on a case-by-case basis. And this is what they said: whether a particular clause in the Constitution consists of an amendable clause or not will be fact-intensive determination to be made after due analysis of the Constitution, its foundational structure, its text, its internal coherence, the history of the clause and the constitutional history, and other non-legal consideration permitted by our canon of constitutional interpretation principles." End of quote. The above finding, in my view, poses difficult questions. Who is to carry out the fact-intensive determination? And at what stage in the process of constitutional change? The appellants told us, and rightly so in my view, that in terms of seeking an advisory opinion, Wanjiku has no place, as by dint of Article 163, Sub-Article 6, this is a preserve of the national government, a state organ, or a county government. I reproduce therein the provision of that article. Since Wanjiku does not have the luxury of approaching the Supreme Court under Article 163, Sub-Article 6, how does Wanjiku get to have an issue subjected to fact-intensive determination? Sight should also not be lost that judges, being human, are not infallible, and they should not arrogate unto themselves the unfettered power to validate or invalidate amendments on the basis that they are eternal causes from their preferred reading of the Constitution. If for a moment we were to find that judges are fallible, where will be the unwritten constraint? The absence of constraint, no doubt, leads to uncertainty and absurdity. In an article by Adan Kassier Abebe entitled "The Substantive Validity of a Constitutional Amendment in South Africa," appearing in a South African journal, I'll just read part of what he said in that article. The idea of a judicially enforceable implied limits on the power of constitutional amendment is particularly unacceptable in cases where a constitution explicitly outlines the fundamental principles and subjects such principles to amendment, as is the case in South Africa. In the absence of a clearly defined and enforceable substantive limits, the judicial control of constitutional amendments will lead to a situation where courts effectively arrogate the role of the people and their elected representatives in defining a polity's fundamental values over which there may be a reasonable disagreement. The absence of clearly defined limits also means that every constitutional judge will have his or her own list of what is basic and what is not. The judicial power to define basic social and political values belies the ideal that courts should merely apply settled rules and principles and not discover some vague fundamental values to invalidate the best judgments of the overwhelming majority of the political representative. In the absence of clearly established substantive limits and an explicit jurisdiction to enforce substantive limits on constitutional amendments, the power and responsibility of ensuring compliance with any desirable substantive limits lies beyond the courtroom. Only the democratic process or a revolution could legitimately and effectively stymie any attempt to legitimize undemocratic behavior through constitutional amendments, end of quote. Similar sentiments on infallibility of judges are expressed in an article entitled "The Conundrum of Unconstitutional Constitutional Amendments" by Paul Jen Yap, and he states, "The people may not always be right, for popular sovereignty is not an absolute guarantee of substantive justice, but neither are judges infallible in their moral deliberations. In these circumstances, the judiciary must cede to the expression of popular sovereignty, not merely because the amendment is an unmistakable expression of public will, but because this convergence of interests is undisputable evidence of the triumph of the political process over the intervening institutional and electoral barriers erected by the separation of governmental powers," end of quote. In my view, it is not correct to elevate judges to the status of demigods, and just as it is possible to have a distrustful and rogue parliament, it is also possible to have a rogue and distrustful judiciary, more so bearing in mind that the latter are not elected as the people's representative. I know that as Kenyans, we love to demonize our elected political leaders. We do this all the time, but rarely do we stop to remember we get the leaders we deserve. I am therefore of the persuasion that the contest of what is amendable and what is not should not be left to be a matter of judicial innovation. Judges, just like parliamentarians, cannot assume supremacy over all others, as indeed it is the people who are sovereign. Article 1, Sub-Article 1 of the 2010 Constitution screams out, "All sovereign power belongs to the people of Kenya and shall be exercised in accordance with this Constitution," end of quote. The people of Kenya, in the exercise of their constituent power in a referendum, voted for the amendment of the pre-2010 Constitution. In came the 2010 Constitution with provisions on how it can be amended in accordance with this Constitution. On the ultimate expression of the will of people, I find an article by Yaniv Rosnai on constitutional amendments to be telling. And allow me to read this passage. He says, "Constitutional amendment seems puzzling. The Constitution is the highest positive legal norm. The power to amend the Constitution presupposes the same kind of power as the one to constitute a Constitution. It is a supreme power within the legal system, and as such, it can reach every rule or principle of the legal system. If this power is indeed supreme, how can it limit itself? If it is limited, how can it be supreme? This is the legal equivalent of the paradox of omnipotence. Can an omnipotent entity bind itself? Both positive and negative answers to these questions lead to the conclusion that it is not omnipotent. Moreover, if the amendment power is a kind of constituent power, then it remains unclear why a prior manifestation of that power prevails over the later exercise of a similar power. Quite the reverse, according to the principle, a later norm should prevail over aquative status. Finally, the Constitution, which expresses the people's sovereign power, binds and guides ordinary law, which expresses the Parliament's ordinary power. The common meaning of unconstitutionality is that an ordinary law, inferior to and bound by the Constitution, violates it. How can unconstitutionality refer to an act carrying the same normative status as the Constitution itself? The question posed by Yaniv Rosnai is, the question that he has posed, why a prior manifestation of that power prevails over the latter exercise of a similar power, underscores the people's will to amend the Constitution without a prior manifestation of that power prevailing over the subsequent exercise of a similar power. Suffice to state that in the 2010 constitutions, Kenyans recognize their constitutional right to amend the Constitution as long as this is done in the manner provided in the Constitution. If perchance the framers of our Constitution had intended that there be a limitation on the power of amendment, they would have provided as much. There are no such limitations in Chapter 16 of the Constitution. And at the risk of being repetitive, I reiterate there is no clause in the 2010 Constitution that prohibits amendments, but there is an inbuilt mechanism that provides safeguards, and I'm of the persuasion that the High Court erred in imposing another hurdle on the basis of an implied provision anchored on the spirit or overarching theme of the Constitution. In my view, the High Court erred in invoking the spirit of the Constitution without the need to do so, given the clear and ambiguous language of the 2010 Constitution on amendments. It is also my view, as explained above, that the findings of the High Court were not supported by the context, structure, and history of the Constitution 2010. The upshot of the above analysis is that the appellant's appeal on the non-applicability of the basic structure is for allowing. However, this is subject to the majority decision of this court. So much as relates to the issue of the basic structure. The next, I shall then proceed now to look at the role of the President, the role of His Excellency, the President in the BBI process. I think for a start, for me, the beginning point is Article 131(2)(c) of the Constitution, which requires the President to promote and enhance the unity of the nation. And with the noble intention, on 9th of March 2018, His Excellency the President, Uhuru Muigai Kenyatta, held talks with the former Prime Minister Raila Odinga that culminated in what is now commonly referred to as a handshake. The intention of the handshake was to bring to an end the political disharmony, demonstration process, and disgruntlements that arose with the outcome of the presidential elections held in August 2017. The handshake would then become a political tool to calm the nation that was deeply divided and to allow for consensus building. I think the history about the formation of the task force, as well as the formation of the steering committee, were well captured in the introductory part of this judgment that was done by the President of the Court. And I will not repeat that, but suffice to state that it is not in dispute that the task force on building bridges to Unity Advisory Task Force was appointed by His Excellency on 24th of May 2018, and subsequently this gave way to the steering committee, and that the process leading up to the formulation of the Constitution of Kenya Amendment Bill 2010, in my view, was largely driven by the executive, as it is difficult to truncate the BBI task force and the BBI steering committee from the submissions of the letter by Honorable Junet Mohammed and Honorable Waweru as promoters of the Constitution of Kenya Amendment Bill 2020. It is clear that one thing led to the other until the culmination of the letter of 18th November 2020 by Honorable Junet Mohammed and Waweru and Honorable Waweri to the IEBC seeking approval of the format to be used in the collection of signatures. Article 256 and 257 of the Constitution provide for amendments by way of a parliamentary initiative and not a popular initiative. The proposals by Honorable Junet and Honorable Waweru would best have been channeled through a parliamentary process, as they were heavily laden with the executive arm. The route of popular initiative was not open to them, as this was not a Wanjiku-driven process. There was an alternative argument that although His Excellency the President Uhuru Kenyatta, was not a promoter of the Constitution of Kenya Amendment Bill, it was contended that nothing stops him from being a promoter of a popular initiative in his own personal capacity, as it may well be possible that a president may find himself in a peculiar position that she does not enjoy the support of Parliament, hence he would be locked out of both the parliamentary as well as the popular initiative. Mr. Kiragu Kimani, Senior Counsel, while urging the appeal on behalf of His Excellency, submitted that the President under Article 38 of the Constitution of Kenya has a right to make political choices just like any other Kenyan, and that the term initiator that was used by the High Court in reference to His Excellency the President was not recognized in the Constitution, and that there was nothing that barred the President from being a promoter of the bill, that the President has a right to campaign for any political party or cause. Further, that Article 12 of the Constitution provides that every citizen is entitled to the rights, privileges, and benefits of citizenship, subject to the limits provided or permitted by this Constitution, end of quote. It was contended that if we were to find that His Excellency the President in his personal capacity cannot use the route of a popular initiative, then this would be tantamount to denying him his rights as a citizen. In my view, the balancing of the rights of a sitting president poses a challenge, as it is difficult to make a demarcation when a president is acting in his personal capacity vis-a-vis his official capacity. Can a president cease to be a president without handing over power during the tenure of his office? In the circumstances of this case, we were told that His Excellency Honorable Uhuru Kenyatta was not the promoter. Indeed, the High Court acknowledged that His Excellency the President was not the promoter, and they coined the term initiator, a term not anywhere in the constitutional amendment process. Be that as it may, the question to be answered is whether His Excellency the President can be a promoter of an amendment bill. In my view, I would liken the situation to that obtaining in the military, where military personnel are often said to be children of a lesser God, to the extent that some of their fundamental rights are limited by virtue of their joining the military. Regrettably, by conduct, there are limitations placed on public officers as to what they can do and what they cannot do. I liken the position of His Excellency the President to that of a judge, where one is a judge 24/7, and it is difficult to say when he or she is not acting in his official capacity. Given the above, it is my humble view that His Excellency the President cannot therefore be a Wanjiku for the purposes of Article 257 of the Constitution, and to this extent I'm in agreement with the High Court findings that His Excellency the President cannot initiate changes to the Constitution through a popular initiative as provided in Article 257. The third item that I will go into is the issue of the legality of the BBI Task Force and the BBI Steering Committee. As to the issue of the legality of the BBI Task Force and the Steering Committee, and as explained above, the Task Force and the Steering Committee were born out of noble intentions of His Excellency the President. Both were ad hoc committees appointed by His Excellency the President for purposes of advising him on the discharge of his constitutional mandate in fostering unity in the nation. The question of illegality of the BBI Task Force had actually come for consideration before Mativo J, who had considered this issue and had come to the conclusion that His Excellency the President acted within his powers under Article 131 and 132 of the Constitution. This was in the case of Third Way Alliance. I've also had the advantage of reading the draft judgment of my sister, Okwengu J.A., and I'm in agreement with the sentiments expressed therein that the BBI Task Force and the BBI Steering Committee were not illegal outfits. On the issue of the presidential immunity, I shall not take much time on this, save to agree with what the High Court said, that when it comes to civil proceedings, the President is not insulated if he does anything or fails to do anything in his own personal capacity. Then there is the issue of the quorum of IEBC. On the question of quorum of IEBC, the appellants and the respondents in support of the appeal challenged the High Court findings that the IEBC was not quorate for purposes of its business, including the verification of signatures in support of the Constitution of Kenya Amendment Bill 2020. For a start, the IEBC is an independent constitutional commission established pursuant to Chapter 15 of the 2010 Constitution. Article 250, Subarticle 1 sets out the composition of an independent commission. It reads, each commission shall consist of at least 3, but not more than 9 members. On the other hand, Section 5 of the IEBC Act provides that the commission shall consist of a chairperson and 8 other members appointed in accordance with Article 250, Subarticle 50 of the Constitution and the provision of this Act. What I would like to say as regards this issue, or my finding, is that the IEBC, as currently constituted with 3 members, cannot be said not to be constitutionally compliant. And the question that I ask myself, if with 3 members, the commission is constitutionally compliant, and it can continue to operate because it is constitutionally compliant. In circumstances like those, can one really say that for purposes of carrying out its deliberations, the members of a quorum in a meeting must be 5? In my view, I think the constitutional provisions take precedence, and if the commission, as currently constituted, is constitutionally compliant, it can carry out its mandate. Members of the commission, I think it would be absurd to say that it must have, for it to be correct, there must be 5 members. I've also made comments on the 2 cases of Biwott, as well as the case decided by Mwita, as well as the one that was decided by Okwany. But additionally, it is my considered view that
I have had the advantage of reading in draft the judgment of my learned brother, the Honorable Musinga, President of the Court, for which I am grateful. My Lord President has undertaken a thorough account of the pleadings and the procedural history of the petitions that were before the High Court, as well as of the consolidated appeals, together with the submissions made by the parties. I will thus not rehash much of what he has so helpfully delved into, and will only refer to some of the arguments made before us where necessary for contextual or illustrative purposes only. The themes I consider it necessary to pronounce and give my particular opinion on in various degrees of depth and breadth are the following: basic structure doctrine, popular initiative, jurisdictional objections, legality of BBI process, public participation, presidential immunity, legal regulatory framework for constitutional amendment by popular initiative, IEBC quorum, voter registration, format of the referendum question, constituency apportionment and delimitation, and then a comment or two on the cross appeals and on costs. Now, on the basic structure doctrine, of all the holdings of the High Court, none have come under furious and sustained attack by the appellants, aggrieved thereby, as those relating to the basic structure doctrine. Hours of argument were added to the thousands of pages of scholarly and judicial authority marshaled by opposing parties in an attempt to cast as blatant and mitigated error, or for their defenders, pure genius, the first of the learned judges' dispositive pronouncements on the doctrine. Supplementing their written submissions with eloquent and passionate addresses, the aggrieved appellants were categorical that the Triple Declaration amounted to a rewriting of our Constitution and was wholly antithetical to settled jurisdictions far removed from our particular circumstances. In his opening address, the learned Solicitor General, Mr. Kennedy Ogeto, took the view that the Constitution has no place for the doctrine and all its provisions are amendable in accordance with clearly set out procedures for various aspects of it. The Constitution has no eternity clauses, and Kenyans consciously avoided the basic structure by making no mention of it. They struck a proper balance between hyperamendability and rigidity by including which entrenched provisions with special amendment procedures. That theme was taken up by Mr. Oraro, learned senior counsel, who posited that unamendable or eternity clauses cannot be recognized unless they are stated expressly in the Constitution. When pressed to point out where the doctrine was rejected, where exactly it was rejected in the report by the committee of experts, he responded, apparently without irony, that entrenchment was implicitly rejected. Answering another question about Colombia, he said that the Colombian case was an outlier and it is a divided country and we should not follow its example by acknowledging an implicit existence of a basic structure and an amendability in our own Constitution. He next made the submission that the case at bar was the first time the basic structure doctrine was applied in our jurisdiction. It had been adopted by the Indian Supreme Court in the Kesavananda Bharati versus State of Kerala and another way back in 1973 in India. And even though it was accepted in Bangladesh, Council's view was that it has been rejected elsewhere and it is inconceivable that we can introduce it in Kenya. Mr. Raro was emphatic that our Constitution provides for its alteration and that as such the people can make any amendment they deign, including, should they so desire, an amendment to abolish Parliament. That being the case, it is not open for judges to unilaterally come up with standards not provided for in the Constitution, thereby raising the bar of amendability. He fervently lamented that the High Court, quote, wants us to be subject to an academic doctrine invented by the Indian Supreme Court, end of quote. Also opposed to that doctrine was Senior Counsel Mr. Orengo, whose opening salvo was that it presupposed that the people as sovereign do exist without or outside the Constitution, which he considered to be fallacious. He was rather dismissive of the learned judges, charging that, quote, they were so anxious to apply the basic structure doctrine that they invented it, end of quote, which he termed, quote, a trip to Wonderland, end of quote. Moreover, he said, the learned judges were accused of being merely ideological and failed to notice that even the Indian judges were not agreed on what constitutes basic structure, and he therefore asserted that every article of the Constitution is amendable so long as it is done constitutionally. That narrative was taken up by Mr. Mwangi, learned counsel for the BBI Secretariat, and the Right Honorable Amolo Odinga. Such analysis, according to counsel, was deliberately undertaken with the aim, that's the historical analysis, with the aim of justifying the basic structure doctrine, and he took issue with the fact that the judges quoted articles by Yashpal Ghai and Jill Cottrell, Alicia Vernon, and James Gandhi, and made scant mention of the report on the Constitution of Kenya Review Commission, of the Commission, which is the official history of constitution making. He sought to distinguish the Kesavananda case, which he stated has a dark past, as posited in the book The Indian Supreme Court and Politics. On the whole, counsel was derisive of the unamendability doctrine as, quote, the product of New Age scholars, end of quote, whose concepts, quote, are not employed elsewhere in Africa, end of quote. And he urged us to follow the example of Uganda, which rejected it and ruled what he saw as foreign ideas being tried on us. Turning to theology, he pleaded that to accept the notion that certain parts of the Constitution cannot be changed would amount to idolatry, under which we would have hoisted the Constitution to a position that is higher than man, and thereby will have made ourselves servants, yet the law is made for man, not the other way around. He urged caution, lest the spirit of the Constitution should create a legal theology. Dr. Otiende Amolo, senior counsel, also took that view, but seeming to make so slight a concession that the doctrine does apply, learned senior counsel asserted that even then, the learned judges treated it as in a wholly unsatisfactory manner that left it in, according to him, utter confusion. Even though the IBC, whom he represents, did not directly appeal against the basic structure doctrine, learned senior counsel Professor Githu Muigai still made submissions germane to the issue. He made the bold assertion that the 2010 Constitution did not rewrite the foundations of the law of Kenya, which remain the same as they have been since 1897. He then complained that the learned judges adopted an approach that supports the view that nowadays all political, social, and economic grievances are being taken before the court, yet the High Court has limited jurisdiction to entertain constitutional grievances where a clear cause of action exists. Orders at large leads to an erosion of the dignity and sanctity of the court. And then he asserted that 9 out of 10 of the learned judges' orders are opinions born of their acceptance of an invitation to act as a philosophical tribunal. Mr. Kuyo, the learned counsel for the National Assembly, also urged rejection of the doctrine. But in the present case, he considered, as he had to, that 74 amendments proposed in the BBI bill were numerous, He nonetheless invited us to reject the doctrine unless we should find that there is a threat of hyper-amendment of the Constitution. For the Senate, Mr. Learned Counsel Mr. Job Wambulwa was also against the doctrine. He urged us not to follow Indian jurisprudence on the subject, given the fundamental textual and contextual differences between our constitutions, with the Indian one reposing amendment powers with Parliament by a simple majority. For the county of Kiambu, Ms. Njoki Mboshe, who, in support of the appeal, declared that nobody can legally, by eternity clauses, oust Wanjiku's sovereign right to self-determination, went on to emphasize that the basic structure has no place in Articles 255 and 257 of the Constitution. She urged us to exercise abundant caution in borrowing foreign jurisprudence. For the County Assembly of Kirinyaga, Land Council Mr. Ndegwa Njiru was equally opposed to the doctrine, and returning, he made reference to the Kivuitu, Priscilla Ndululu Kivuitu and another versus the Attorney General, and he said that he considered that the court there did recognize the basic structure doctrine, but added that once the people were involved through a referendum, it was within their rights to alter the basic structure. Mr. George Albert, Land Council, was of the view that Kenyans chose 10 articles to protect from amendment by requiring that they be subject to a referendum. And according to him, the terms basic structure, eternity clauses, and unamendable clauses are used interchangeably. Against those attacks on the learned judge's acceptance and endorsement of the basic structure doctrine was an equally eloquent and impassioned battery of counsel. Mr. Harvey, appearing with Ms. Angawa as land counsel for the first to fifth respondents, extolled the 2010 Constitution as a perfect charter. He took grave issue with the BBI proponents who proposed, according to him, 74 amendments by a single stroke of the pen, thereby dwarfing the 38 amendments to the independent constitution carried out between the years 1963 and 1991. He was emphatic that the doctrine of unamendability and basic structure actually is implicit, and that changes to that core structure can only be effected through the exercise of constituent power with four features, namely civic education, public participation, debate, and referendum. He was quick to add that the constituent power is not textualized in the Constitution, but is definitely applicable, and he placed reliance on the judgment by Justice Ringera in the Njoya case. Pointing out that the constituent power did not originate with the Ringera J, counsel made reference to John Locke's two treatises of government and Baron de Montesquieu's The Spirit of the Laws, to assert that it is neither emergent nor alien, as it is rooted in antiquity as a feature of democratic governance. Pointing out that the basic structure is already part of the Kenyan jurisprudence, having made its first entry with the Njoya decision, he asserted that there are limits to amendability. Citing Nwabweze and referring to the preamble to the Constitution, he urged that the Constitution is indeed intended to endure for ages to come. It thus did not matter whether or not the basic structure was textualized as such, and he called in aid other doctrines such as the separation of powers, checks and balances, independence of the judiciary, etc., which, though not spelled out in the constitutional text, are nonetheless an integral part of the Constitution. Asserting that a strict scheme of amendment did not justify repeal of the Constitution, and that the two are in fact dichotomous, Mr. Harvey made an appeal to history, stating that amendment powers had led to effective repeal of the independence Constitution. He pointed out that Justice Ringera had acknowledged that, but mentioned that there was no challenge to those amendments. Such fate should not befall the 2010 Constitution on account of the, quote, according to him, fortunate, successful challenge mounted by his clients against the 74 proposed eviscerations of our permanent charter, end of quote. Citing the writings of various jurists, including Professors Richard Albert and Yaniv Rosnai, counsel warned of the dangers of populist constitutionalism characterized by constitutional capture. He also refers to Dr. Mutaha Kangu's constitutional law of Kenya on devolution, in which he accepts the basic structure as applicable in Kenya. To him, the BBI proposed amendments destroy, eviscerate, and dismember the Constitution's basic structure by creating an impure presidential and parliamentary system, domiciling the cabinet in the legislature, thereby obfuscating legislative and executive functions, contrary to separation of powers, and interfering with judicial independence by creating and installing what he called an executive prefect over it in the name of an ombudsman. Mr. Mutuma, counsel, argued in favor of the doctrine, adding that courts bear more than obligation to defend the Constitution, as they are invested with the authority to defend it. He made a distinction between amendment and repeal by making reference to Black's Law Dictionary. So stating, he posited that the BBA initiative and Constitution Amendment Bill was an attempt to repeal the 2010 Constitution by implication. This is impermissible because the said Constitution is for eternity, which he explained to mean, quote, for as long as we have it. Next came Professor Kithure Kindiki, learned counsel, who posited that there is a hierarchy of constitutional norms. And to demonstrate the basic structure, he posed the question whether one can amend the Constitution to change Kenya from a multi-party democracy into a constitutional monarchy, or alter its territory by having a part of it donated to another state, as had happened elsewhere in history. To him, such fundamental changes require a direct involvement of the people. He went on to say that the judges did not say that the basic structure cannot be altered, as the complaining appellant seemed to project, but rather that such changes must be subject to a deeper process involving the sovereignty of the people. He went on, indeed, appealing to us to dismiss the appeals with costs. He turned all spiritual, submitting that the BBI process was a botched attempt to overthrow the people and the Constitution, but, quote, by the mercy of Almighty God, the High Court intervened and declared it a nullity. Next came Dr. Mudhomi Thiankolu, who invited us to consider a quartet of questions. What kind of precedent do we want to create? What incentives for constitutional compliance will we put in place? How will future presidents treat the Constitution? Should we lend to this, according to him, illegality, judicial imprimatur? And how will politicians behave in the future? Resorting to Greek mythology, counsel implored us to recall the Hydra of Lerna, that multi-headed sea monster, which he likened to the impunity that has stalked this land, and urged the judiciary to be as steady as the sword as was the hero Heracles, and so slayed by upholding the judgment of the High Court. Learned Senior Counsel Dr. Kaminwa was categorical that the 2010 Constitution came about in answer to our rotten past and in response to global jurisprudence. Quoting from various books, he said that the 2010 Constitution was Kenya's way to sending a never again message to all that had gone wrong with us before. He declared that the Constitution is unamendable by the methods proposed in the BBI initiative and bill. The basic structure is not confined to India, but has spread worldwide. He was categorical that the problem in this country is not with the Constitution, but with ourselves, and especially with the politicians, quote, most of whom are mere job seekers who stand for absolutely nothing, end of quote. He urged us to throw out this appeal as unmeritorious. Equally scathing was Ms. Martha Karua Lana, Senior Counsel, who appeared for the professors of law who had been admitted as amici curiae before the High Court, positing that constitutions exist to limit the excess of authority. He lamented that in Kenya, the executive, state entities, and state officers ignore the fact. Stating that Under Article 165, the courts can make determinations whether anything done is constitutional. He pleaded with us to hold that the Constitution is yet to be fully implemented as the final word on its interpretation. She asked us to mark the beacons for excesses of power by the executive and to, quote, uphold and protect the basic structure which is part of the DNA of the Constitution, end of quote. She was joined by Ms. Nyanguto, Land Council, who argued that the basic structure is inherent in the Constitution and urged us to uphold it and thus protect the Constitution from the BBI bill, which, quote, portends the death of the 2010 Constitution by 1,000 deadly cuts, end of quote. Coming next, Learned Counsel, Mr. Zebedeo Ongoya, argued that the judges did not merely import the doctrine from India, from Indian case law, but rather found it in the history, text, and structure of the Constitution. In doing so, they developed a rich indigenous jurisprudence in a manner that was praiseworthy and not objectionable to deserve the attacks directed at them. He made reference to the decision of Lenaola J, which has been referred to in the Commission for the Implementation of the Constitution versus National Assembly. He went on to say that the learned judges were correct to delineate three types of sovereign power, namely primary constituent power, secondary constituent power, and constituted power germane to a determination of the questions at bar. This same theme was echoed by Learned Counsel Mr. Evans Ogada, who submitted that when the judges pronounced themselves on the basic structure doctrine, they were declaring a legitimate reality and were not merely engaging in lofty theory. Land Counsel Mr. Ochel Dudley distilled three strange positions, according to him, that this court would have to simultaneously adopt in order for it to overturn the learned judge's findings on basic structure. Those three are: one, we would have to adopt textualism, we would have to elevate the political elite above the people, and finally, we would have to upset a settled theory of constitutional change. Referring to the case of Kesavananda, he indicated that our position is no less perilous than that faced the Indian courts, because we have 74 missiles that are trained at our constitution. To him, changing the constitution is not a normal state function, but an extraordinary authority. He pointed out that the power to amend is not authority to annihilate the Constitution, which he warned could easily be abrogated by gradual amendments. He referred to the writings of Hans Kelsen to assert that the Constitution is the Grun norm. It has to be accorded a more stable character. Thus, it is not enough for those intent on altering the Constitution to just marshal the numbers, recalling that such formally compliant machinations have happened before. Learned Counsel, Mr. Madenge, took the view that the text of the 2010 Constitution in fact supports the basic structure doctrine because the Constitution has a core content and contains fundamental prior principles that are immutable in character. Making reply to all that, Mr. Nyamodi contended that the basic structure and the basic structure doctrine are not synonymous. The former refers to fundamental entrenched provisions which the Constitution contains, while the latter restricts amendability of the Constitution, a notion he rejects, as all provisions, according to him, are amendable, albeit by use of a different procedure where entrenched provisions are concerned. Finally, he considered that Professor Rosnai is undoubtedly an authority on the basic structure doctrine, but invited us to find that the intensity of judicial review of proposed amendments depends on the amendment process involved. Mr. Donald Kipkorir, Learned Counsel, maintained that the basic structure doctrine was inapplicable in Kenya. And he seemed to suggest that it would be archaic and a phenomenon from classical Greece, where constituent power, this a case about theory and not a live one about live people. He repudiated the idea that a constituent assembly is any more effective an exercise of power and authority than the people's exercise of sovereign power to effect or ratify radical changes to the Constitution at a referendum. He urged that the BBI Amendment Bill was not trying to reenact the Constitution because it left 90% of it intact. I have taken the trouble to set out only the oral submissions made on this fundamental issue of great significance, even though I have painstakingly read and pondered over the copious written submissions filed, as well as the numerous authorities cited. Before I go into a detailed analysis of the arguments, I'm skipping quite a bit because of time. Before I go into a detailed analysis of the arguments, and specifically the case law and academic writings, I must confess that hearing the positions taken by some of the parties before us had an air of the surreal about them. Some counsel spoke of the basic structure doctrine as if it was a novel and unheard of idea that had just set foot on our jurisprudential shores for the very first time. It was projected as a thing of pure theory, a hypothetical chimera, never before applied to real situations. Moreover, the manner in which this country's long and painful search for a new constitution was projected by opposing parties left me wondering whether we had facts and alternative facts. Well, I will refrain from drawing any inference that any of the learned counsel before us were out to mislead the court, at least at this point, and give it the most charitable interpretation that texts sometimes speak differently to different readers. But counsel should nevertheless endeavor to apply their best mind to extract the true meaning of the constitutional text as well as the judgments and academic writings on a subject. Only then can they be truly said to have assisted the court and shown themselves honest guides as required of advocacy at the bar. I do not consider it necessary to go into a detailed history of the making of the 2010 Constitution. Suffice it to say that its promulgation, which is seen as the birth of the Second Republic, was the culmination of many years of struggle and pain, sweat and tears, in which liberty, limb, and life were harmed and lost so that Kenyans could have a better life of freedom and dignity, and in particular, that they could have a government that is answerable to them and leaders who serve them, not lord it over them. The Constitution is a charter of liberty, the embodiment of a new deal, and a break from a past characterized by oppression and suppression of freedoms as simple and essential as expression, association, and assembly. The one-party state, first de facto, and then by the instrumentality of the rushed amendment that brought in the infamous Section 2A of the retired Constitution, installing the Kenya African National Union as the sole political party de jure, brooked no opposition. Treason, sedition, public order, foreign exchange restrictions, and a motley other laws were used to beat the populace into submission. Detention without trial, torture, prosecutions on trumped-up charges, confiscation of passports, and many other misdeeds marked the darkest days of independent Kenya. The spirit of our nation is a resilient one, however, and buoyed by and inspired by happenings elsewhere, including the collapse of the Berlin Wall and the reforms occurring in the former Soviet Union through the policies of glasnost and perestroika, there was sustained agitation for more democratic space. In time, Section 2A was repealed, reintroducing multipartyism, and through false starts and faltering steps, the new constitution was born. It was the product of phenomenal public participation and driven by bold Kenyans represented as the ordinary Wanjiku, who might as well have been Auma, Amina, Chela, Mwende, or Mura, and all of their male equivalents. Kenyans gave their views on what ailed their land and their institutions of governmental power. Their cry was for a more equitable share of resources, and ensure that their voices were heard before they declared in a detailed preamble that they were, among other things, honoring those who heroically struggled to bring freedom and justice, proud of our diversity, recognizing the aspirations of all Kenyans for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law, and exercising their sovereign and inalienable right to determine the form of government of our country, and having participated fully in the making of the Constitution. To my mind, this preamble provides the context and setting, the background and canvas against which an analysis or interpretation of the Constitution must be undertaken. The Constitution was not the product of an immaculate conception. Rather, it was the product of a rich experiential milieu of legal, social, and political interaction, more particularly captured in numerous historical accounts of trial and ultimate triumph, including the final reports of the Constitution Review Committee and the Committee of Experts. Any court interpreting the Constitution must perforce be alive to the historical background if it is to do justice to the text of the Constitution. Anything short of that would be drab, dry, and skeletal at best, lacking the pulsating animation of a living document possessed of a spirit and an ethos. Indeed, as if fully aware of the easy slide to dry formalism in construction, an obsession with text and lexical renderings, oblivious to history and context, the Constitution itself provided the keys to its construction in explicit terms in Article 251(1), which is that it must be interpreted in a manner that promotes its purposes, values, and principles, that advances the rule of law and the human rights and fundamental freedoms in the Bill of Rights, that contributes to good governance, and every provision of this Constitution shall be construed according to the doctrine of interpretation that the law is always speaking. It seems to me plain beyond argument that fealty to the constitutional text itself throws open the pathways of interpretation to the end that one must look at what the Constitution provides in a manner that is wide and imaginative, so that it should be given the fullest amplitude of meaning and intent. The interpreter must have the purposes, values, and principles of the Constitution ever in mind as he undertakes the task. What is called for is purposive, value-laden, and principled approach to constitutional interpretation, as opposed to a narrow, neutral, and ultimately neutered formalism. Moreover, those charged with interpreting and giving effect to the Constitution cannot shut their eyes to, or be indifferent to, or worse, evince a hostility towards the rule of law, human rights, and fundamental freedoms. The Constitution commands judges to be active participants in those causes, and it behoves us to constantly introspect and deliberately push forward the rule of law and the human rights project. It would be a serious dereliction of duty, productive of deleterious effects, were those charged with the solemn duty of advancing these causes to be found wanting through carelessness or inattention, thereby either stalling or reversing them. To me, stringent urgings for judicial restraint where the rule of law is under threat and human rights are abused are totally antithetical and anathema to the plain constitutional interdict. Where these matters are concerned, fealty to the judicial oath demands, nay, commands, conscious activism. We do not become judges to subvert the plain and uncompromising edict to advance the rule of law and human rights. To my mind, that the Constitution very deliberately calls me to be a warrior for the rule of law and human rights, and to be both faithful and fearless in the cause is beyond question. Precisely because the law, as with life, is not static, the Constitution calls upon those who interpret it to do so in a manner that permits the development of the law. This is an acknowledgement that our knowledge of law is not at its zenith, and none can boast of having attained the acme of legal omniscience. This is where we are called upon to be open-minded, even to those concepts that may at first blush seem strange or challenge our long-held beliefs. We live in a globalized world, and courts will always be part of a continuing conversation on comparative constitutional law and practice. We are part of a global community of courts, and we definitely can and do benefit from a cross-pollination of ideas. We receive and consider those that have migrated to us, being careful to accept and incorporate those that can be said to be markers of positive development, even as we should think that our own progressive jurisprudence is solid enough and sufficiently persuasive to other jurisdictions. That, to me, is the constitutionally ordained interpretative prism and lens through which I must approach and decide the applicability of the basic structure doctrine to our Constitution. I proceed from the appreciation that the Constitution is laden with normative fecundity, which should vivify all persons who are charged with its application or interpretation. I've mentioned some provisions, and I say those provisions are couched in plain and peremptory terms, requiring no further exposition. I need only state that the obvious fact that this obligation, unquestionably binding as it stands, takes on a more solemn aspect, sacred even, in the case of those who occupy certain state offices by first swearing allegiance to the Constitution. Such oaths are of the gravest import and not to be lightly taken or regarded as mere formal incantations, empty rituals bereft of meaning or substance to be violated with no consequence. Those who swear by the Constitution must be prepared to live by it and defend it as commanded, or else give the officers that come with such burdensome demands on their loyalties and consciences a wide berth. It should be plain by now that the approach to constitutional interpretation that persuades, indeed binds me, is a purposive and holistic one, which repudiates the text as the alpha and omega on the divination of the meaning and intent of the Constitution. One needs only cast a glance at our history of constitutional jurisprudence to see the long shadow cast by a textualist obsession as exemplified in Republic versus Elman back in 1969. That approach, thankfully long interred, although every once in a while we hear its ghost clanging its chains, seeking a place at the interpretative table, declared that the Constitution was to be interpreted in the same way as any other statute and frowned upon any resort to the spirit of the Constitution in derisive and almost epithetical terms. The fortunes of Elman doctrine have been traced in Mudhomi Ntiankolu's Landmarks from Elman to the Saitoti ruling, searching for philosophy of constitutional interpretation in Kenya. It is no wonder that for long periods of Kenya's post-independence history, constitutional guarantees of freedom and fundamental rights remained for the large part, mere pious platitudes. And I see this as an object lesson for those of us on whom falls the obligation to give meaning to what the Constitution provides. We must learn from the mistakes of history, lest we be doomed to repeat them. It only takes a restrictive, minimalist interpretation here and a textualist, formalist approach there for the spirit of the Constitution to be stymied and its lofty ideals to hemorrhage towards barrenness by a drip drop of near imperceptible clawbacks and innocuous seeming small steps of mark time, slide, and reverse. And I need only add that the Supreme Court has recognized that the 2010 Constitution is a transformative charter to be understood and interpreted as such. In much the same way as new wine cannot be stored in old wineskins, it would be totally illogical to try and squeeze a transformative constitution within the suffocating straitjacket strictures of formalistic or positivistic interpretation. I have no difficulty whatsoever following the fresh and expansive interpretive path blazed for us by the Apex Court in several pronouncements. I've quoted them. I've quoted the Supreme Court in the interim Independent Electoral Commission case. And then in the matter of the Speaker of the Senate, the Supreme Court characterized the 2010 Constitution as having gone beyond the usual parameters of liberal constitutions with its deliberate aim of attaining social change and reform as spelled out in the preamble, part of which I have already adverted to. The aim of that transformative approach is to recognize and reset the interplay of majoritarian and non-majoritarian institutions of the state so as to reach the desired governance goals. It is not difficult to see that such a constitution can ill afford a mean-spirited and narrow-minded interpretive approach, as that would totally negate and defeat its transformative aims of facilitating the socio-economic and political growth of the country. This is identified in the Supreme Court Act, but flows from the Constitution itself and must guide all courts in interpreting the Constitution. I have agreed with the words of Chief Justice Emeritus Mutunga in the Speaker of the Senate and another versus the Attorney General. Only to take perhaps one sentence from there, it is in this context that the spirit of the Constitution has to be invoked by the court as the searchlight for legal illumination and elimination of these legal penumbras. From my analysis of their judgment, the learned judges were faithful to an interpretative scheme that was holistic, cognizant of the transformative character of the 20th century Constitution, purposive, and properly contextual. That approach accords with my own understanding of what the mental orientation of a court undertaking interpretation of our Constitution ought to be, and I would accordingly reject the criticism leveled against the learned judges. I do not accept the attempted denigration of their acknowledgement of the spirit of the Constitution, as if recognition of the spirit of the Constitution was some spiritist animist retreat to a dark and ignorant or superstitious past. To the contrary, every legal instrument does have a spirit and soul that animates it. Learned authors of Black's Law Dictionary, 11th edition, trace it back to 1802, more than 2 centuries ago, and explain that it is also termed as the spirit of the law and means, quote, the putative intention of the creator or creators of a legal instrument, as opposed to its literal content. This is to be contradistinguished from the letter of the law. And they also treat of the spirit of a letter conception, which is of much recent birth, born in 2014, which they define as, quote, the notion that the spirit of the legal text should prevail over the letter. As far as the spirit of the Constitution is concerned, we endorsed it in the case of the Independent Electoral Boundaries Commission versus Mena Kia and others way back in 2017, where among other things we said the constitution of a nation is not simply a statute which mechanically defines the structures of government. It is a mirror reflecting the national soul, the identification of ideas and aspirations of a nation, the articulation of the values binding its people and disciplining its government. The spirit and tenor of the Constitution must therefore preside and permeate the process of judicial interpretation and judicial discretion. I believe in those words we were quoting the Supreme Court in the matter of the interim independent electoral commission. We dare say that in the context of the Constitution there is an ever-present spirit that relentlessly pervades its provisions. As a consequence, that spirit, which is always speaking, must be discerned as an integral part of interpreting the provisions of the Constitution. Now, does the basic structure doctrine apply to the Constitution of Kenya 2010, thereby limiting its amendability? The learned judges went through 50 paragraphs of more than 20 pages of history. I do not wish to repeat that history. I've already given I've given a brief overview of the same, but some of the marks of it, some of the high points or low points include the CKRC draft constitution, the post-election violence of 07, Agenda 4, etc., etc. The High Court's engagement with the basic structure doctrine was with that history firmly in view. The case made before them was that the 2010 Constitution contains essential features and critical characters and fundamental values that enjoy transcendental existence, whose derogation is not contemplated in the Constitution by way of constitutional amendments. It thus forms eternity clauses of unamendable provisions. Upon intense analysis, the learned judges pegged their conclusions partly on the people's demand for and insistence upon the direct involvement through conscious and informed participation in the constitution-making process, and I have quoted them. Indubitably, the people were not mere observers or peripheral players in the making of the 2010 Constitution. They were wielders and shapers of destiny, not mere instrumentalities for the formal adoption of a document conceived, gestated, and birthed by the political power elites of the day, only for them to attend and vote at a referendum that would be no more than a ritual naming of a product not their own. The recorded history is crystal clear that the people of Kenya conceived, composed, and constituted their constitution, which they birthed in 2010. And it is only natural, in the way of the Swahili saying, uchungu wa mwana aujuaye ni mzazi, it's the mother who knows the pain of childbirth, as contrasted with my native Kisi saying that mwano wandima miri makendu, another's child is but cold phlegm, that the people of Kenya were very particular that the child of their own making, in which resided their hopes, dreams, and aspirations, as well as a clear statement and architecture of how they wish to be governed, should not suffer the fate of the previous constitution. That other had been amended many times in a deliberate and systematic scheme to quarter it, water it down, dismember, and all but obliterate the promise of freedom for the citizens and limited government that it once had. They expressed their views to CKRC, which I have quoted, and the concerns about constitutional dilution, abrogation, or capture through amendments were also captured. Indeed, they said, considering how quickly and fundamentally the Independence Constitution was amended, how can we protect the new constitution from a similar fate? I'm quoting from the CKRC report. And then they also asked, how can we prevent the decay of constitutional institutions and state organs, as has happened with the institutions of the present constitution, the past constitution? Now, it is a sad blight on Africa's post-independent experience that no sooner did the nations gain independence than the power elites embarked on diluting and dissolving all restraints on power and authority, a blurring and final obliteration of checks and balances and a concentration of power in the presidency. They did this principally through facially legal and constitutionally compliant changes to their constitutions. I have immersed myself in the writings of Professor Nabueze relevant to this subject and taken account of his description in excruciating detail and depressing detail of the manner in which power became so concentrated in the hands of the founding fathers, the heroes of independence, to the detriment of good governance and the rule of law and the liberty of citizens. In Presidentialism in Commonwealth Africa, for instance, he dedicates chapter 5 to the office of the president and starts off under the head, the extent and reality of presidential power, by pointing out that the most striking feature of the presidency in Africa is its tremendous powers. He goes on to state, which I consider germane to quote in extenso for a full appreciation of the reality that informed Kenya's search for a new constitutional paradigm. He said many things, but just one sentence I will quote there. The Africanness of the presidency in Africa refers to the fact that it is largely free from such limiting constitutional devices, particularly those of a rigid separation of powers and federalism. Now, he talks about aggregation of power, concentration, etc. So that aggregation and concentration of power, with the attendant creation of imperial presidency, was achieved mainly by constitutional amendments. To achieve them, the restrictions to the amending powers built into the independence constitutions were assaulted and successfully abolished or attenuated. Ghana, the first country to attain independence in 1957, was quick to abolish all the restrictions to amendability, even and especially of entrenched provisions, the very next year by the Constitution Repeal of Restrictions Act of 1958, which was passed strictly in accordance with a prescribed procedure. Thereafter, a simple majority sufficed for every constitutional amendment. the proponents of the abolition of restrictions to the amendment power, including Nkrumah himself, castigated them as a colonialist imposition, an affront to the sovereignty of the new state, and a perversion of the democratic state. I must confess, it did give me an uneasy sense of déjà vu when I heard similar arguments made before us in condemnation of the learned judges for deigning to find that there is a limitation to amendment of the 2010 Constitution. Nobweze then recounts the Kenyan experience under which the provisions relating to entrenchment and thus restriction of amendment power were systematically removed or watered down. I believe this particular part was also quoted by my learned brother, Mr. Justice Gatembu. I will not go over it again. After detailing the same trend in Uganda, Tanzania, Malawi, and Zambia, the author observed quite correctly, in my view, that whereas amendments per se may not be objectionable, quote, too frequent amendments may tend to reduce the Constitution to the level of an ordinary law, depriving it of any claim to respectability and devotion, which might in time earn for it a status akin to sanctity. Kenyans were keen to ensure that the 2010 Constitution did not suffer the same ignominious fate as its predecessors, and they told the CKRC that its amendment had to be restricted. And I have quoted the report on what the people said and the commentary by CKRC, where indeed they concluded the people therefore wanted a fairly rigid arrangement, the amendment of which would require their participation in some form. In their view, the new constitution should only be amended in the same way in which it is made. I have laid emphasis on the last part of the commentary because, to my mind, the people of Kenya were quite clear that they were not going to cede the constitution to the vicissitudes and vagaries of political expediency. Having birthed it, they were prepared to nurture it and protect it from mutilation or dismemberment. They desired to be involved in its fate and fortune, and were essentially saying that only as they made it could it be substantively altered with their full and informed participation. It is clear to see, therefore, that the people, as creators of the Constitution, were exercising a power that was without and above the Constitution. They could not have been creating it pursuant to any of its provisions for the rather commonsensical reason that it was not existing at the time, not having been constituted. The power to constitute a constitution predates the Constitution, and it is with great respect quite absurd to seek constituent power within the Constitution. The power is original, a priori, primordial, and is inherent in the sovereignty of the people. It is not subject to the Constitution, which is but an emanation of it. This is the constituent power with which the people themselves, acting directly, can both make and replace a constitution. I've quoted Nobweze. The Njoya decision, which Ringera actually quotes Nobweze, was never appealed against and has remained the law on this subject, followed and reaffirmed on many occasions over the last 15 years. I have gone over Ringera's judgment, Ringera J's ruminations on the subject of constituent power, its being an expression of the sovereignty of the people, its existence outside the Constitution, yet having implicit recognition in it with a cognizable juridical status. Having done so, I think I can do no better than set out at some length what he had to say, with which I fully concur and apply mutatis mutandis to the 2010 Constitution, but because of time, I will not read all of this stuff that he said. The relevance of the constituent power to a discussion of the basic structure doctrine is that it is presented as the only authority that can effect a legitimate alteration to an aspect of the Constitution that lies at its core or relates to its essential character. The argument is that amendments or alterations of that kind are not amendments properly so called, but have the effect of abrogating it or destroying the very foundations or pillars upon which it rests. I've quoted John Rawls in Political Liberalism, where he says, he gives an example of whether the Americans could decide and amend the first Constitution, the First Amendment and replace it with an opposite fundamentally contradicting principle, such as establishing a state religion. Such a move would amount to a constitutional breakdown or revolution in the proper sense, and not a valid amendment of the Constitution. Professor Robert Albert, in an article called Constitutional Amendment and Dismemberment in the Yale University Law Journal of International Law, states that this Rawlsian view reflects the conventional understanding in the field of constitutional change. Either a constitution is amended consistently with the Constitution, or the alteration is so transformative that we cannot call it an amendment, and we must instead recognize that conceptually it creates a new constitution. Under that view, this would be the case even if the old constitution is not formally replaced with a new one. It can safely be argued that any amendment that alters the core aspects of a constitution, changing its character and ethos in a radical manner, is essentially changing its basic structure, and in all but word abrogates or dismembers the Constitution. The basic structure doctrine and the notion of constitutional dismemberment have the same effect of positing that such constitutional amendments are in fact unconstitutional. I've quoted the concurring opinion of Mr. Justice H.R. Khanna in Kesavananda. And I just want to mention that it's important to note that the Indian constitution, just like ours, did not then and does not now contain unamendable provisions in its text. It lacks express limitations to its amendability. This is in contrast to some other jurisdictions in which the constitutions contain provisions prohibiting amendment of certain subjects, leading to the terminology, as Professor Raznai notes in his PhD thesis, the terminology of immutable, unalterable, irrevocable, perpetual, or eternal, all of which he considers, and I readily agree with him, to be inaccurate. Why? Because they imply everlasting provisions, but they are neither eternal nor unchangeable. While they serve as a mechanism for limiting the amendment power, they do not and cannot limit the primary constituent power. Moreover, their content can also change through judicial interpretation. The Brazilian terminology, which refers to these provisions as Petraeus clauses, which I understand, that's me, which I understand to mean founded on rock. Petraeus clauses, to express their rigidity, is more accurate in that respect, since even rocks cannot withstand the volcanic outbursts of the primary constituent power. Therefore, in order to describe the legal situation more accurately, I refer to these provisions throughout this thesis as unamendable, as opposed to eternal or eternity clauses. The scholar notes that the technique of expressing prohibiting the amendment of certain state features, be they the form of government, separation of powers, or the like, spread like a fire in a thistle field, or, if you like, in the Gikomba clothes market, and was impelled in part to protect the Constitution by guarding against what he calls popular levity and legislative caprice. He then concluded that just as having a formal constitution virtually became a symbol of modernism following the American and French Revolution, so too nowadays having an unamendable provision is becoming a universal fashion. But importantly, he points out, which is germane to the analysis whether the learned judges were wrong in arriving at the conclusion they did, that the amendment power must be conceived as implicitly limited, even in the absence of any explicit limits. And he traces this back to the United States back at the dawn of the 19th century, refers to the works of John Calhoun in 1851, who wrote a book called Discourse on the Constitution and Government of the United States, and then also Thomas Cooley's Stories Commentaries in 1893. All these speak to the notion of intrinsic limitation to the amendment power, and it is not much different from the basic desire of Kenyans, I referred to earlier, that their constitution be altered only by the same means by which they made it. In Germany, the scholar Carl Schmitt was of the same view, that no revision of the constitution could provide for the destruction of its legitimacy. In short, the Constitution does contain a core of implicitly unamendable principles which embody its identity. According to Rosnai, the argument in favor of implicit limitations on amendment powers did not remain in the realm of theory, but migrated from Germany to India in the 1960s, where, due to stormy political events, it was applied practically and most notably elaborated. I have indicated and traced the fact that that theory, doctrine, had an incremental fate in India. It was rejected in the case of Shankari Prasad versus India, and then it was again rejected in 1965 in the case of Singh versus Rajasthan. The first foothold of that doctrine was when a narrow majority of 6 versus 4 versus 5 of an expanded bench in Golaknath versus State of Punjab reversed those earlier holdings without invalidating the amendments in question. I need to mention here that that great break was contributed to by the writings of Dietrich Conrad, a German professor of Asian law, that had been placed before the court by one of the petitioner's lawyers, one M.K. Mambior, and I have indicated that this goes to show the value of research. When lawyers do good research, you get good results in the judgment. Now, the Golaknath decision, however, unleashed the wrath of a furious Prime Minister Indira Gandhi and signified the opening shot of the Great War over parliamentary versus judicial supremacy, and I've traced all that. When we came to Kesavananda, there was an extraordinary bench of 13 Supreme Court judges, and a narrow majority of 76 held that the amendment power does not include the power to alter the basic structure or framework of the Constitution so as to change its identity, and this is the kernel, the heart of the basic structure doctrine. Now, the majority faced reprisals from Gandhi, most notable being that her breaking with custom to appoint Justice Ray, the senior-most of the dissenting judges, as Chief Justice instead of the senior-most judge of the court, who happened to have been in the majority. Now, in Indira Nehru Gandhi versus Raj Naram, 5 judges unanimously confirmed the basic structure doctrine in 1975. Come down to Minerva Mills versus Union of India in 1980. Again, there was a unanimous holding that held that insofar as a certain section there removed all limitations on Parliament's amendment power, it conferred on it the power to destroy the Constitution's essential features or basic structure, and this was beyond the amendment power and thus void. Now, contrary to submissions that were made before us, the basic structure doctrine, from my reading of the cases subsequent to Kesavananda, demonstrates an ascendant trajectory to the point that it is firmly settled as a doctrine in India. The split majorities of its inception gave way to consistent unanimous decisions of the Supreme Court, so that the so-called compelling case by R. Dhawan, said to be a respected advocate and leading Indian scholar, that Kesavananda ought to be set aside would seem to have no solid foundation in my respectful view. It has stood for more than 50 years, or about almost 50 years now. When I turn to other cases, in Malaysia, for example, I have quoted 2 cases from Malaysia which seem to show that the doctrine was more accepted than repudiated. I have also taken time that taken note that other Asian countries such as Bangladesh and Pakistan have embraced and fully affirmed the basic structure doctrine. I've quoted some cases there. And citing various cases from far west, Central and South America, specifically Argentina, Belize, and Colombia and Peru, Rosnai comes to the conclusion that the basic structure doctrine has migrated far and wide across the globe. Some of the arguments that were made before us here were made in the in Belize, and the Supreme Court in the case of British Caribbean had this to say. They referred to the Indian basic structure and then said, though the Constitution of India is different in several respects from our Constitution, both constitutions have basic structures, features such as judiciary, rule of law, fundamental rights, and separation of powers. As I have stated before in this judgment, constitutional borrowing, cross-pollination, and interpenetration of notions is perfectly legitimate and is the proper way to develop the law while ensuring that whatever is borrowed is relevant, useful, and fitted to suit our particular circumstances. I need only add that the legal scholars have recognized and encouraged constitutional borrowing by courts for persuasive purposes, and the whole amount of articles. Can constitutional borrowing be justified? In the University of Pennsylvania Journal of Constitutional Law, and then constitutional borrowing in the Michigan Law Review. I note with a measure of bemusement that while castigating the learned judges for relying on foreign jurisprudence, the aggrieved appellants have laid before us numerous decisions of foreign courts. I was at first minded, I have mentioned some of the things that were quite off in the manner in which the submissions were made. We were told that cases said one thing when in actual fact they said something else. I'll give an example. In one of the submissions, it was said that in Uganda, the Supreme Court, in the case of Paul Semogerere and others, equally dismissed the Kesavananda doctrine. And then they quote a passage that I think was quoted by one of my colleagues this morning about those who make the Constitution know what's good for them, etc., etc. And then, but now, this is what I say. Now, after reading, from a reading of that passage quoted by counsel, the impression is that all those words were by Mr. Justice Tesekoko of Uganda. But in truth, only the last paragraph contains his words. Now, having read the Semogerere judgment myself, which was usefully, if ironically, supplied by counsel in volume 8, I cannot but respectfully conclude that the case does not at all advance the appellant's particular argument or case. First of all, it turns out that the bulk of the excerpt attributed to Judge Tesekoko are not his words. They are actually words apparently found in a Kesavananda dissent, which the judge quotes not directly from the judgment, but as said to be quoted in a Singaporean case. The judge himself puts it thus at page 8 of his judgment. He said, no copy of the judgment of Kesavananda case was availed to us. I have not been able to lay my hands on the full judgment, but passages of it are quoted in the Singaporean case of Sesolung. Now, with great respect, I cannot see how it is possible for Semogerere to have dismissed Kesavananda, as we are urged, when the judges deciding it had not even engaged with the doctrine and had not even read the judgment. In fact, nowhere in Semogerere is there a whiff of rejection of the basic structure doctrine, which is the heart and essence of Kesavananda. To the contrary, Tesekoko J. indicated that in his considered opinion, Kesavananda case was misunderstood and therefore misapplied to the petition that was before the Constitutional Court. And then he talks about what he thinks Kesavananda, which he didn't read, was about. Now, I need not say anything on the judge's understanding of the issue in Kesavananda, which I, unlike he, have read in full. But it should be obvious that given the infirmities I have pointed out, Semogerere, as presented before us, cannot be a basis for the contention that the basic structure doctrine was rejected in Uganda on that occasion. The same also goes for the case of Male Mabirizi and others versus the Attorney General of Uganda, where it seems to say, the judge said that the basic structure doctrine is still at a nascent stage of development. This is a 2018 decision, but from what I've said, the basic structure is not nascent, it's not new, it has actually grown quite old. Now, having undertaken so detailed an account and analysis of the Indian experience with the basic structure doctrine and its migration across the globe, I have no difficulty discounting those conclusions as untenable. I would also reject the decision cited to us of the Honorable Attorney General of Tanzania versus Christopher Mtilika, because there the court said, the Court of Appeal of Tanzania, it said that the courts must eschew a loosening of judicial discipline in interpreting the explicit provisions of the Constitution. And they went on to say that a tightening of judicial scrutiny would be necessary. Now, I think that that is the very antithesis of what our Constitution requires of our courts. I cannot accept as a correct reading of the Constitution, less still a persuasive one, for me to follow the conclusion reached there that everything is amendable once the procedure for amendment is followed and that the basic structure doctrine does not apply. The conclusion I have arrived at, out of my forays into the jurisprudence and learning I have referred to, and much more besides, is that the basic structure doctrine is legitimate and sound. I would think it's strange that anyone would doubt the existence of a basic fundamental essential core, being the pillar upon which the Constitution stands, and from which its character, ethos, and identity flows. There is a certain undeniable simplicity to the notion. I thought of it as a house. Any and every house, be it simple, complex, and elaborate, must have some structure with its bare essentials. Even as some houses have fewer items than others, going into their basic structure than others, so would different constitutions differ in complexity. I was pleasantly surprised to see that Joseph Raz, in a book called Between Authority and Interpretation, uses the analogy of a house to differentiate between minor changes to the Constitution, like redecorating a house, and major ones that alter its character. Rosner refers to that very analogy of a house. I will not say much more on what he says. I've cited a passage at length to signify my full agreement with the learned judges that the amendments proposed by the BBI initiative and bill were so far-reaching in character, scope, and content as to shake the foundation and alter the identity and character of the Constitution. They were effectively dismembering the Constitution, blasting so huge a hole in it as to pulverize its foundations and essentially create a new constitutional order. To do so would not be to amend the existing Constitution, and therefore there was need to resort to and summon the primary constituent power. The mere invitation of the people to vote on the radical transformative proposals at a referendum was not an effective summons of the correct authority, because the people acting on the amendment plane constitute the secondary constituent power only and are limited to amendment. They are in no position, while acting in that capacity and space, to endorse and effect a constitutional replacement. This latter they can only do in primary constituent mode. Now, Rosnai, I believe, asserts crucially that the amendment power is a constituted power even if exercised by the people. Moreover, no constituted power should be entitled to abolish the democratic system. To my mind, that is the cognitive posture that we should adopt in answering the question whether the notion of limitations to the amendment power discussed by so many courts loses any of its logical force by the fact that the amendments proposed in the case at bar and contemplated by Article 255 and 57 of the Constitution require approval by the people in a referendum. The conclusion appears to me inescapable that as long as what is contemplated is an amendment, it will ipso facto be limited. The limitation in this case stems from the fact that certain aspects of the proposed amendments unquestionably go to the essential core and fundamental fabric of the Constitution, thereby purporting to alter irredeemably its character and identity. Such radical alterations are not amendments in the real sense of the word, for there has to be a limitation to what amendments can achieve. And I would think that dismemberment is dismemberment, whether effected through surgical amputation or through rough mutilation. It matters not whether you carve Caesar as a dish fit for the gods or hew him as a carcass fit for hounds. The cuts are mortal either way. I have said enough, perhaps more than enough, to show that I do not think a sufficiently compelling case has been made to warrant our interference with the conclusion that the learned judges reached with regard to the basic structure doctrine and its applicability in Kenya. I have gone back to what Lenaola J. had to say in the Commission for Implementation of the Constitution was National Assembly. I am fully in concord with the reasoning. I'm so fully in concord with the reasoning of Lenaola J that I will not add a single jot or tittle to his reasoning. Having come to the conclusion that the basic structure doctrine is applicable, the conclusion is also inescapable that the amendment power set out in Article 255 to 257 of the Constitution is limited, and that the basic structure can only be amended through the constituent power. That constituent power can only be properly summoned and exercised in accordance with the four-sequence process of civic education, public participation and collection of views, constituent assembly debate, preceding a referendum. And this accords with the holding in Njoya. I would hold without hesitation that a referendum cannot be effective as contemplated by the constituent power unless the initial three steps have been involved and engaged in real and substantive, as opposed to a ritualist and minimalist manner akin to a mere token ticking of boxes. Ringera J said, all in all, the limitation of Parliament's power was a very wise ordination by the framers of the Constitution, which is worthy of eternal preservation. I think, with respect, that the amendments to the Constitution contemplated and proposed by the BBI Amendment Bill have the potential to alter by one fell swoop, the fundamental pillars that define and undergird our Constitution. They are truly no less than a ballistic attack on our Constitution's foundations, including separation of powers, independence of the judiciary, and Chapter 15 commissions and independent offices, not to mention supremacy of the Constitution, sovereignty of the people, and the national values and principles of governance. I accept that this is not exhaustive and should be dealt with on a case-by-case basis. Ringera J indicated that we have been down this road before, but without judicial challenge. I surmise that a cowed populace probably did not have the courage to seek redress, nor was the judiciary back then particularly famous for the defense of the Constitution. For the superior courts of this country at this time, there is no luxury of indifference or neutrality. Where in former times no challenge to the manifest alteration of the Constitution's basic structure was made, thus sparing the court the burden of decision, we are today summoned to the valley of decision. Civic-minded Constitution-defending citizens have raised alarm at the threatened dismemberment of the 2010 Constitution. The High Court has, with crystal clarity of reasoning and felicity of dictum, raised a barricade against such a scheme, and it is upon this court to either raise the bulwarks of defense even higher and place around the Constitution a wall high and impregnable against such machinations, or, as we are urged by the appellants, we disable the brakes, uproot the ramparts, and usher in an open season for the systematic and unbridled dismemberment of the Constitution. To me, there's only one path that commends itself consistently with conscience and fealty to the constitutional command. I must defend it and keep its fortifications firm and effective. I must stand up for the Constitution, heeding the words of the hymn, where duty calls or danger, be never wanting there. I have referred to the aspect of illiberal democracy and its growth, and I've talked about Professor Rosalind Dixon and David Landard. The point they point out that the constitutional amendments or basic structure doctrine, though at times attacked as being anti-majoritarian and making courts too powerful, is in fact a useful tool to help preserve so-called fragile democracies against the democratic erosion that is inherent in abusive constitutionalism. Beyond textually stated eternity clauses, they point out that many scholars and courts have argued that the doctrine can be defended. Now, however, given I am persuaded that the referendum requirement is at best an exercise of the people's secondary constituent power, or, as argued by some, an aspect of the constitutive power contemplated by the Constitution itself as part of its amendment procedure, I am better persuaded by the unconstitutional constitutional amendment basic structure doctrine. I am justified by this view, by my appreciation that even referendum procedure can be made of no effect by a deficit of prior civic education and public participation. Indeed, someone has said that for populists, a referendum isn't meant to start an open-ended process of deliberation among actual citizens to generate a range of well-considered popular judgment. Rather, the referendum serves to verify what the populist leader has already discerned to be the genuine popular interest as a matter of identity. An effective bulwark against abusive constitutionalism, therefore, seems to me to be on the authorities, one that entails more as opposed to less people involvement. I think, therefore, that there is nothing anti-majoritarian or doctrinally abhorrent about the four-step process the learned judges held to be indispensable for effectuation of amendments of the kind proposed by BBI. It has to be recalled that the restriction to amendment need not be in express text. It is generally accepted that in keeping with the interpretive posture addressed earlier in this judgment and on a proper understanding of the basic structure doctrine, the limitation can be implicit. Therefore, it is the people themselves who preferred rigidity over flexibility. They were bothered by hyper-amendability, and for me, the numerous amendments proposed are no less offensive because they are presented in one bill at once and not through staggered installments over time. Justice Chandrachund in Casavananda stated that the basic structure's theme song is "Amend as you may, even the solemn document which the founding fathers have committed to your care. For you know best the needs of your generation. But the Constitution is a precious heritage. Therefore, you cannot destroy its identity." In short, it is undeniable that by using the basic structure doctrine, the judiciary does play an important role against democratic erosion, and I would, without hesitation, affirm the learned judges on the basic structure. My voice is running out, so I will just make a few comments on the other issues. Popular initiative. I have held that in the amendment scheme of the Constitution, it is clear beyond peradventure that as far as the characterization of the amendments to the Constitution go, there is a binary reality with two distinct, dichotomous, and disjunctive initiatives, the parliamentary one or the popular one, each providing a distinctive methodology or procedure. And what appears clear from the Kenyan experience is that the popular initiative was introduced as a response to citizens' frustrations with Parliament, to whom the law-making power is delegated. It was not always acting in a citizen-centric manner and often acted in a manner quite inimical to the interests of the public. The popular initiative is therefore a mechanism for the people to exercise direct authority in the amendment of the Constitution. It is a power reserved to them as the sovereign to do that which Parliament may have defaulted in doing. This is consistent with Article 1, Sub-Article 2, which provides that the people may exercise their sovereign power either directly or through their democratically elected representatives. Admittedly, this form of active, direct, and deliberate democracy is quite new in the African experience, but has been around for quite a while in other parts of the world, referred to variously as the constitutional initiative, mainly in America, or citizens' initiative in Europe. It has certain discernible characteristics which are pointed out. Now, one of the things to note is that in an article by Maya Setale and Theo Schiller, editors, Citizens' Initiatives in Europe, Procedures and Consequences of Agenda Setting, the author draws a valid and useful distinction between compulsory referendums, which are for constitutional changes proposed by the government or the parliament, and the popular initiative, which allows for any other group outside of the parliament to put a proposal on the table. By the term popular or citizens' initiative, we refer to procedures that allow citizens to bring new issues to the political agenda through collective action, that is through collecting a certain number of signatures in support of a policy proposal. The role of these citizens' organizations, social movements, civil society organizations, etc., they are the ones who lead the and these are contradistinguished from the direct democratic perspective executive that trusts in the people to initiate the direct decision-making process. In this range, we have the popular initiative, the popular referendum initiative. From my reading of the literature on these subjects, I am fully fortified in my view, which coincides with that of the learned judges, that a popular initiative is a citizen-conceived, citizen-initiated, and citizen-driven process. And these are the ordinary mwananchi. If the initiative is born of presidential fiat, no matter how well-intentioned, it ceases to be a popular initiative and must be recognized and named a state or presidential initiative. Now, in answer to the question whether what happens when the president has a parliament that doesn't listen to him, I do not doubt that the president, with his wide array of powers and influence, could have used the parliamentary initiative through his party and others with which he works, or could work in a coalition of the willing to bring about the changes to the constitution that he seeks. The president's role in the conception and initiation of the Building Bridges initiative is writ large, and with it, the panoply of power and prestige of his office. First was the handshake, then the BBI Gazette, which was appointed by, task force was appointed by Gazette, which is an official government publication. The task force prepared a report, which it presented to the president as president and commander-in-chief. Moreover, the president again appointed the steering committee on the implementation by way of a special issue of the Kenya Gazette. Their report was presented to the president at a state lodge. That everything about the process bore the imprimatur of state involvement. It was a presidential government project, and this was wholly antithetical to the popular initiative. Like Machiavelli's prince, the president's conduct is different from that of ordinary citizens. In acknowledging this plain and in spirit of fact, one does not thereby curtail the president's enjoyment. One might even say deployment of his personal or political rights. All it means is that the space upon which he elected to exercise his rights is reserved for ordinary citizens, the common populace of the Republic of Kenya, and it is not open to the president. It is out of bounds to him. The question is, first of all, hypothetical, but to my mind, the president does not shoulder any obligation to initiate constitutional changes. He takes office under and in accordance with the Constitution, and his duty is to obey and defend the allegiance, not to change it. It follows from my reasoning that I agree with the learned judges that the president took certain actions at the inception of the BBI process, including appointing the task force and later the steering committee by Gazette notices in his capacity as President of the Republic of Kenya and Commander-in-Chief of the Defense Forces. The popular initiative path, a preserve of the ordinary citizen, was not available to him for initiating any amendments to the Constitution. I would dismiss the grounds of appeal challenging that finding. Next, jurisdictional objections. I do not think there was any merit in the claim that the matters were either sub judice or were res judicata, and I've dealt with that wholly. I agree with the judges on that point. Let me rush quickly to the legality of the BBI process. I've said things there that initially that already give an answer to this. But given there was never indication, I should start here. A number of critical facts stand out in crystal clarity from that Gazette notice which appointed the steering committee. Regarding the steering committee, which taken singly, together, or wholly, go to declare that it was a presidential creation and a government project tasked with inter alia proposing constitutional changes for the implementation of the report of that very team in its previous emanation as the BBI Advisory Committee, and the facts are there, I've stated them. Given there was never any indication that citizens of this country had, in and by themselves, conceived of the idea to change the constitution in a particular manner as the genesis of this process, but appear only to have been roped in to respond to what had already been given life and motion by the president when he appointed the task force, the process that was being undertaken was not a popular initiative. And it matters not that it may eventually have gained the liking or admiration of many people. That sense of popular is not what is meant by the Constitution, which uses popular in the sense of pertaining to the general public or ordinary citizens. The BBI Steering Committee, by inception, composition, and operationalization, was a government presidential project. The members were not ordinary citizens who came together, coalescing around an idea that the constitution needed to be changed in particular respects. Instead, these were prominent personalities joined together by presidential fiat. They had no mind or idea of their own to initiate, but were instead tasked to identify constitutional, among other changes. It was not open to them to purport to craft constitutional changes and even come up with the BBI Constitutional Amendment Bill purportedly as a people's initiative. They were, without a doubt, a government project, and it was impermissible and untenable for them to seek to camouflage their process as a popular initiative, which it was not. They were essentially seeking to hijack the People's Initiative route under Article 257 of the Constitution, and this was clearly intolerable and indefensible. It was also contrary to the letter and intent of the Constitution. That, I think, provides the answer to what I had to say about that aspect. Yes, I think I am dealing with, yes, public participation is the next point. And under public participation, I have indicated the Constitution itself, a product of super participation on the part of the people of Kenya, recognizes participation of the people as one of the national values and principles of governance. It is listed in Article 2A alongside patriotism, national unity, sharing and devolution of power, the rule of law and democracy. I have no hesitation holding that participation of the people is what gives meaning to and serves as the guarantor to the tangible realization of the other values and principles of governance. It is what gives substance and brings to life reality the idea that democracy is a system of government of the people, by the people, for the people, as famously put by U.S. President Abraham Lincoln in his Gettysburg Address on November 19, 1863, which he hoped shall not perish from the earth. Participation by the people is in the matters that concern them, when done in a deliberate, substantive manner, acknowledges the sovereignty of the people and treats them as master of their own destiny. Their autonomy, individually and as a collective, is mainstreamed, even as the paternalistic state and its officers that so easily assume the position of ex cathedra directives recede to a facilitative as opposed to a... Yes, there's an aspect. I agree with the judges generally when they talk about public participation. The above reasoning is perfectly in line with the public participation with what it would require in a matter of such moment as constitutional amendment. I must express my unease, brought out quite poignantly by Mr. Karori in his address to us, that it would be to place an onerous and well-nigh impossible burden on a constitutional amendment by popular initiative to expect them to go the whole hog captured in the above excerpt, including translating it into all the languages, having it in Braille, etc., and sending it all over the country. That to ask them to do that before they collect the signature would be a bit too onerous. It seems to me, with respect, that the requirement stated by judges must be present before or at the time of the voters finally make their decision on the proposed amendment of the referendum, failing which the mandatory requirements for public participation will not have been met, with fatal consequences to the proposed amendment. I am of the view, however, that the elements of public participation stated must perforce be understood to form a spectrum or a continuum which is incremental in character. It would be way too expensive and onerous to expect that citizens seeking to introduce amendments, be it by way of a general suggestion or a formulated bill, must engage and involve the voters, by which the learned judges must be understood to mean the national vote pool, from whom the promoters would be seeking the 1 million supporters, to the broad and extensive elements of public participation enumerated by the learned judges. I think that the duty they bear at that point of signature collection is one of sensitization with candor and disclosure, as opposed to one of full broadcast by all means, in all languages, to all voters of the full particulars of the exact amendments by way of the amendment. It is enough that a voter should know by amendment in sufficient detail to be able to make a decision whether it is an initiative he would support by appending his signature at that stage. To that extent only, would I respectfully fault and advise the learned judges while leaving intact the and holding on public participation with regard to the totality of the process up to the referendum. been argued that why worry about public participation? The way you look at everything else, the way it is set out, there will be enough moments for public participation, and perhaps the judges acted too fast and too soon. And I think, with respect, that whereas on paper the argument does sound attractive, the reality on the ground, as became apparent during the hearing of the appeal, is that there was a measure of cynical disregard for the very opportunities and timelines intended to facilitate public participation. Even for the signature collection, for instance, it turns out that the IBC apparently published the list of the persons listed as supporters of the initiative to facilitate confirmation by the people that the list was accurate, thereby seeming to involve them. This was in reality a mere show, devoid of substance, however, for the reason that the list was published by the IBC on the IBC website only, and then the public were informed of the fact on Thursday, 21st January, and were required to have notified IBC of any complaint by the following Monday. With a weekend in between, it means that the people of Kenya were given but 2 days to access information available only on a single platform. Under those circumstances, it sounds rather strange for IBC to point at the apparent absence of complaint as demonstrative of accuracy or satisfaction. It could well have been due to absence or, at the very least, insufficiency of access. Another glaring and troubling example that was cited in argument before us was the lightning speed at which the amendment bill was rushed and passed through county assemblies. The Constitution deliberately indicates that they are to consider the bill within 90 days. And it is argued that properly so, that the period is intended to facilitate public participation, which I take to take the form, at the minimum, of publication of the bill within the county, followed by consultation, receipt of memoranda, debate in public forums organized for the purpose, and on other platforms so as to involve the people and obtain their instructions, thereby establishing whether or not to support or approve the bill. What was witnessed in most counties, however, was a farcical disregard for the people and the Constitution. Many county assemblies made absolutely no pretense to involve the citizens resident in their counties, spurred on no doubt by certain incentives beneficial to themselves, the most notorious of which was their demand for some 2 million shillings car grant, which was quickly granted by government. The usually slow and tight-fisted Salaries and Remuneration Commission, despite well-known fiscal challenges and a raging global pandemic, somehow managed to prioritize, approve, and find funding for that particular incentive for MCAs, which seems to have attained the status of a national emergency. What in the end seems to have happened in county assemblies was a mad rush to demonstrate personal gratitude and party loyalty, with some passing the bill in but a couple of days. The people did not matter. They might as well not have existed. And no superior court in this country, properly directing itself on public participation, would in conscience accept as permissible such violation and negation of the constitutional scheme and command to put the people first and center in public affairs, of which amendments to the Constitution is definitely the most solemn. I would affirm as correct the holding of the learned judges that county assemblies are under duty to approve or reject a constitutional amendment bill in a popular initiative whole without amendment, so as to maintain and preserve its content and character inviolate as a popular initiative. It is also the more reason why they are under a clear duty to be scrupulously and faithfully discharged, to involve the people so as to discern which way they should vote on the amendment bill. On presidential immunity, all I will say, first of all, is that there was an issue that His Excellency the President, Uhuru Muigai Kenyatta himself, it would have been neater. It would have been neater if the President himself joined the proceedings and raised objection to his having been sued in his personal capacity. But he was not. Now, the issue that arises is that he appears not to have been served, and I might as well state at this point that the learned judges ought, at the very minimum, to have first satisfied themselves that service had been effected on him by the petitioner before proceeding to hear and determine the matter, and to even make pronouncements against him. This is a fundamental and basic tenet of natural justice, and the rules as to service or process are quite explicit as to what is required to have been done. I therefore agree with Mr. Gatonyel, Senior Counsel, that any adverse orders made against the President in his personal capacity would be open to setting aside ex debito justitiae. That does not mean, however, that the learned judge's finding on the extent of the president's immunity from civil suit is also affected, because this is a matter of constitutional law, not personal to the sitting president. And I have quoted Article 143(2), and the argument was that the president should be impeached in case of things that happen outside of his. In fact, the argument was that he enjoys absolute immunity. Now, as an impeachment can be challenged in courts, it was counsel's view that it was putting the cart before the horse for the courts to entertain suits against the president in his personal capacity before he gets impeached. When seeking clarity, I asked counsel the hypothetical question of what my neighbor out in the village of Karaos, Kesogon, Trans Nzoia County would do were I the president and my dog bit his child. It was counsel's confounding answer that the only recourse open to my neighbor was to seek my impeachment. He cannot be right, not least because there is nothing presidential about such a canine indiscretion that would only invite tortious liability. Counsel drew the attention of the court to Article 165 of the Constitution that gives judges immunity, and in particular the case of Bellevue Development Company and Francis Gikonya and 7 others. I am familiar with it. I wrote a judgment in it. But the position I take, is that the protection that is given to the president has to be purely functional, related to his office, and does not extend to any matters that are done outside or in violation of the Constitution. In fact, from my analysis, it is possible to state the law on presidential immunity to be this: the president is immune from criminal prosecution and from civil suit for any act or omission in exercise of his powers under the Constitution in Kenyan courts during his tenure of office. But he may be sued for acts or omissions outside his constitutional duties and prosecuted for international crimes where the treaty establishing them does not recognize the defense of immunity. The statutory limitation period shall be extended to take account of any action or suit that could not be brought on account of the defendant's presidential tenure. I make a distinction between this and the immunity that the president had under the old Constitution, where it was absolute. And I would say that absolute immunity, which existed under Section 14 of the retired Constitution, appears to me to be an anachronism and an oxymoron in the context of a constitutional democracy such as we are, that upholds as part of its national values and principles of governance the rule of law, good governance, integrity, and accountability. Those values and principles, alongside constitutionalism, which denotes limited government, denotes limited government, must mean that the office of president, being a creature of the Constitution, is and must be subordinate to the Constitution, and its holder must be held to account for his acts and omissions. The president is not above the Constitution or the law, and is not a law unto himself or herself. In recognition of that preeminence and importance of the office of the president, the Constitution grants protection to the holder thereof, to the end that he should not be unduly impaired in the performance of his unique duties. That protection cannot, by any stretch of imagination, be extended to cover any and every act or omission, including those outside of or in violation of the Constitution. That seems to me to be the clear meaning discerned from Article 143(2), and the fact that Article 143(4) expressly excludes international crimes from the purview of presidential immunity provides ample proof that its limited conception, character, and extent. Now, the president does not possess powers outside or beyond those donated to him by the Constitution and the law. He, as well as all holders of state and public office, must point to the Constitution or to a law to provide a basis or justification for the powers they wield and exercise. The rule of law demands, as Professor Wade put it, that each act must be shown strictly to have legal pedigree. Indeed, if you look at the case of Nixon versus Fitzgerald that was cited, you will discover that the absolute immunity that the former president, Richard Nixon, was held to have was from damages liability predicated on his official duties. official acts. The immunity was held to be a functionally mandated incident of the president's unique office, rooted in the constitutional tradition of the separation of powers and supported by the U.S. history. Now, what we have in issue here, coming out of petition number 426 of 2020, are those acts which are said to have been committed by the president outside his constitutional powers and in fact in contravention of the constitution. And the land judges held, and I would respectfully affirm, that the president is not immune from suit for that. I only need to add that the days of an accountable presidency are long gone and are of only historical significance as a lesson and a warning to the citizens of the country to be vigilant and to demand accountability from the person to whom they entrust the responsibility of leadership. Experience, as recorded in many cases, both local and comparative, shows that in a democracy, no office is immune from accountability to the law as administered by the courts. I hold that the appeal challenging the landed judges holding on presidential immunity from suit in personal capacity should fail. Regarding the legal regulatory framework for constitutional amendments by popular initiative, I have mentioned some of the arguments that were made. And I would say that I think it's a matter too plain for argument that the country does need a referendum act, and there's none at present. The landed judges were informed that there was a proposed referendum bill somewhere in the legislative pipeline, but there seems to be uncertainty as to its eventual fate. So, it's interesting that, and odd that the Attorney General, who should have been at the forefront in seeing the legislation is in place, the IBC, which needs it for proper conduct of referenda, and the BBI Secretariat, which needs it to be guided by it if it were to pull through the proposed amendments, all seem to speak the same strange language that the gaping lacuna is of no significance or moment. With great respect, I do not find such a stance by critical players in a national exercise to be of great importance to be particularly helpful. And I do hold the view that candor in public affairs, including in litigation, is a virtue to be embraced. It cannot be right for parties to propound in court positions they know to be so plainly untenable and to do so without batting an eyelid. That this country needs a referendum act is an urgent matter and should have been addressed years ago. Now, the Attorney General went on to assert that all motions involving the furtherance of popular initiative are an exercise of citizens' political rights as enshrined in Article 38, but they should not be limited by flimsy excuse of lack of regulations, administrative procedures, or statutory prescriptions not expressly provided for under the Constitution or legislation. That's what the argument was. Whereas the Attorney General is quite right that the enjoyment of fundamental rights cannot be conditioned upon the enactment and promulgation of any statutory rules or regulations, with the absurd result adverted to where rights are held at ransom by official neglect, I do not think that the landed judge's decision was to that effect. I fear the Honorable Attorney General appears to have misapprehended the reasoning of the landed judges, which was quite the opposite of the meaning he ascribes to them. In fact, judges at paragraph 6 or 3 of their judgment say that even if there is no referendum act, it is still possible to under proper with proper adherence to the Constitution, to go right ahead and hold a referendum. I think with respect that given the uncertainties, ambiguities, and penumbras that are apparent in the manner in which one is to go about initiating, collecting signatures, forwarding, debating, involving the public, campaigning, and voting on a popular initiative for the amendment of the Constitution together with the necessary timelines, this area is in a wholly unsatisfactory state and needs clarity by way of both national referendum law and probably rules and regulations specific to the popular initiative. It is disingenuous for it to be argued otherwise unless uncertainty in law should somehow have attained a utility I myself cannot discern and a status of a virtue. I am firmly persuaded that a referendum in the context of proposed constitutional amendments by popular initiative must be governed by a specific, properly thought out legislation. It cannot be left to the Elections Act, which seems to contain a part of the referendum in some kind of by the way or afterthought, regard having heard to the fact that referendums are not elections and they are no less important than elections. I would go as far as to state that whereas the provisions on the referendum in the Elections Act may suffice to settle questions of various types and descriptions in an ordinary referendum, they are not sufficient in detail and clarity and were not formulated to meet the full requirements of Article 257. I should think with respect that it speaks to a national malaise of inattention to duty, a satisfaction with dilatoriness, and being reactive instead of proactive on the part of officialdom, that the referendum law has never been passed, notwithstanding that some 2 years ago, Justice Nyamweya had spoken, Nyamweya J, as she then was, had spoken of its glaring need in the case of Republic versus County Assembly of Kirinyaga, ex parte Kenda Muriuki, and another. Now, in resolving this issue, the issue of verification, I've gone into some depth about it. All I can say that the report was even more emphatic. This is a report that was done by IBC itself in the Okoa Kenya initiative, was even more emphatic on the process of verification, which must entail ascertainment that the status of the supporters as voters and of the authenticity of the signatures as theirs. I agree entirely with the sentiments of the judges, safe to say that the landed judges were perhaps too magnanimous in having been merely startled by IBC's flip-flopping on this rather straightforward matter of what it means to verify. I should think that such shifting of goalposts probably smacked of Kanda economy, calling for stern rebuke. It is a matter of utmost importance that all persons and institutions that appear before court be careful to be entirely forthright. Any other contrary stance brings the administration of justice to disrepute and must not be condoned or normalized. And therefore it boggles the mind that with regard to the BBI proposed amendments, IBC sees its role as different from what it stated with regard to the Okoa Kenya initiative. In sum, there does exist with regard to the counterpart electoral processes full-fledged legal and regulatory framework, and it cannot fall from the mouth of IBC that a like framework for signature verification for a popular initiative is a superfluity, because I think it is not. Given that state of things, I am convinced that the conclusions reached that IBC lacked the requisite legal and regulatory framework in the specific issues of signature verification, and that the stopgap administrative procedures were invalid, were unassailable, and I would not interfere with them. On IBC quorum, I think a lot has been said. I am in total agreement with my brother, Justice Gatembu, when he came to the conclusion that the quorum of IBC cannot be 3. The quorum of IBC must be 5. And to my mind, such a vital role done by IBC requires the full complement of IBC with all hands on deck. It is, to me, another instance of officials' failure on the IBC, which, while fully aware of its current limping status, its commissioners having dropped to below half of what the Act prescribes, for it to wear a brave face and state in legal proceedings, no less, that it's doing just fine. A more honorable stance would have been for the IBC and the Attorney General to make a clean breast of it and consider the former needed urgent help and send an SOS to the appointing authority to bring that intolerable state of affairs to an end by making the necessary appointments to empower IBC for the performance of its key mandates, including the conduct of referenda as stated in Article 884 of the Constitution and required in Article 257. Its relevant statute demands immediate filling of the positions of commissioner that fall vacant. It is fortuitous that interviews have since been conducted, and IBC should shortly be fully constituted and not a day too soon. I think I can leave that particular one and move on to, I would therefore agree with and affirm the landed judges holding that all the decisions made by IBC in relation to the proposed constitutional amendments via the BBI Amendment Bill were invalid, null and void for lack of quorum. On voter registration, again, I've said quite a bit, and the evidence seems to be that IBC had managed to register some 108,000 more voters after the time of the Kibra election of 2018. During argument of the appeal, it came out quite clearly that there really has not been any serious and sustained continuous voter registration. It is also clear that the numbers indicated are measly, to say the least, when thousands of young people are daily attaining the age of majority. And I would say, and not accept the argument made before us that it was upon the petitioner to prove the contrary. He bore no burden, because it is the IBC that keeps the records, and it is it that had the duty to show that there was continuous voter registration. It would have been an unacceptable dereliction of duty and violation of rights were the referendum to be held with hundreds of thousands or millions even of young people sitting it out on account of not being registered. Where the referendum in question involves proposed changes to the Constitution, it is this very segment of the citizenry, the very youngest of adults, who have the greatest stake in the matter, and everything should be done to aid in having their voice heard, their vote taken, and their decision made known. Indeed, it's further testimony of the nonchalance that attends the question that the registration of young people as voters is a matter that has to be pursued as a chore when attainment of majority ought to lead to an automatic registration as a voter. I know that the report by the Kriegler Commission dated 17th September 2008 on this very aspect has never been actioned more than a decade later. They had indicated that it should be very easy. The moment someone gets an ID, they should also be registered as a voter, but that seems not to have been done until now. The format of the referendum question, I would say with respect, again, I agree that lumping all those questions together brings a problem. Already addressed under the rubric of legal and regulatory framework. I have taken the view that Section 49 of the Elections Act does envision multi-question referendum. I would think, however, that whereas the section applies to referendums generally, the specific proposed constitutional amendment under People's Initiative in Article 257 must be presented as a single amendment at a referendum for the people to either approve or reject. On the whole, therefore, I do find and hold that the learned judges were right in holding that specific proposed amendments must be submitted as separate and distinct referendum questions. I would only preface the relevant part of the declaration by the words must be presented singly, or I would in any event reject the grounds of appeal preferred against the holdings on the structure or format of the referendum question. I've taken the view that having too many of them in one question amounts to an interrogatory overload. On the question of constituency apportionment and delimitation, I note that IBC, which to its credit has not appealed against the findings of the learned judges on the aspect of the case, is required under the BBI bill to determine the boundaries of the 70 extra constituencies within 6 months of the commencement of the Act in the counties among which the new constituencies are said to are spread in the manner specified. The learned judges undertook a detailed historical account of constituency delimitations, which goes to show how the matter is a delicate, emotive, and often highly contentious exercise undergirded by what Kriegler report termed the gross disparities in the voting populations and gross disparity in the size of Kenya's constituencies. In a report by the IBRC, it identified historical injustices and past gerrymandering as having highly contributed to the 2007 post-election debacle. Now, I have generally agreed with the learned judges, and I hold without hesitation in rejecting the complaint that the learned judges erred in not exercising judicial restraint or constitutional avoidance, that I am in full agreement with this court reasoning and holding aforesaid, and that is in the case of Coalition for Democracy, CORD versus the Republic. It resonates with what I stated earlier when treating of the basic structure doctrine that the Constitution places on judges an unmistakable obligation to defend the Constitution where there is real, clear, and present danger of violation or contravention of rights or an unlawful tinkering with or alteration of the Constitution's basic structure, such as portended by some of the provisions of the BBI Amendment Bill. The courts, when moved, must take defensive action in aid of the Constitution, even by making a preemptive strike that ensures the threatened constitutional amendments do not see the light of day. I have again seen refer to Mr. Karori's arguments in which he talks about the difference between the power of IBC over wards and over constituencies, which I agree with, but a careful reading of the judgment does not suggest to me that the learned judges held that the number of constituencies cannot be altered. I think they stated the opposite, and quite emphatically and unambiguously so, which again I have quoted them. What the learned judges did hold was that it was impermissible for the BBI Amendment Bill to directly allocate and apportion the 70 extra constituencies it created without the delimitation exercise that is commanded and provided for in detail by to be undertaken by IBC in Article 89, which lists and Article 88.4, which lists the delimitation of constituencies and wards as one of the particular, and I dare say, exclusive responsibilities of IBC. To my mind, the protective role of independence commissions over the sovereignty of the people is of critical over the delegation of the sovereignty of the people is critical and vital importance and can only be attained by a jealous and uncompromising assertion, exercise, and defense of their independence. Independent commissions are charged with the duty of vigilantly and keenly ensuring that the state organs to which sovereign power is delegated maintain the stance of delegates accountable to their principles and remain always the servants of the people. And therein lies the absolute necessity of the independence of those commissions being kept firm and inviolate. I would thus hold that seeing how critical the independence of independence commissions is to the sovereignty of the people, it has to be part of the basic structure of the Constitution, which is given express amplitude by entrenchment. Having taken this view, it should be obvious that I find the provisions of the BBI Amendment Bill to be an unconstitutional attack on the independence of the IBC and materially seek to alter by the operation of various of its provisions the limitation scheme set out in Article 891 of the Constitution. It effectively attempts to repeal that provision without saying so by stealth and subterfuge. Now, it is a statement to the thoroughness of forensic analysis and intellectual engagement the learned judges brought into this aspect of the case, as indeed the entire case, that they proceeded to expound in some detail on each of the 6 reasons or markers of unconstitutionality that they identified in the BBI bill. I'm not have to go into them. As I'm myself fully satisfied with the accuracy and logical legal foundations of those reasons, I do not consider necessary to rehash them. The conclusion is inescapable that being so violative of the Constitution, the provisions of the BBI Amendment Bill were benighted and ill-fated at inception and are to be struck down as null and void. As to the cross appeals, I am in full agreement that both of them should fail, and that's my position. And so, finally, in conclusion, I would express my deep gratitude to all counsel and parties who appeared before us. The depth and extent of learning that went into the preparation of these appeals and cross appeals by both sides of the divide was truly impressive. The authorities were numerous and the workload quite daunting, and I must commend the industry and commitment on display before us. The erudite submissions made passionately and with persuasive force exemplify the importance of oral advocacy at the bar by both seasoned seniors and talented young legal eagles. The latter exemplify Chebe's quip in Things Fall Apart that when a child washes his hands, he gets to eat with kings. These young lawyers will soar to great heights, and should they maintain the discipline, hard work, courtesy, and professionalism that was in prodigious display before us. There is reason for optimism that the future of the profession is safe, despite present troubles. As the cases, textbooks, articles, commentaries, and other authorities were in their scores, running into hundreds, nay, thousands of pages, it was not possible to refer to each and every one of them, just as it was not practical to quote verbatim all the submissions made before us for days, not to mention the hundreds of pages of the same in writing. My not having referred to any of them is no indication of their lack or worth of work or importance, but merely the function of limited space and time. In the end, I trust that we have all kept the Constitution safe and secure on this occasion, and may it always remain so. Thank you.
Well, thank you, my brother Justice Kiage. It is now about 10 minutes to 5, so we'll take 10 minutes health break, then come and finalize the remaining judgments.
What Mr. Oluoch had said is that he had used an email address, and although Mr. Oluoch has said he sued him in his personal capacity, that address seemed not to have been a personal address. But even notwithstanding that, it was imperative upon the court, once it came to the conclusion that the Attorney General could not appear for the President, to have ascertained at that point in time that His Excellency the President had been served with a hearing notice or with a petition. In my view, His Excellency the President was entitled to equality and freedom from discrimination as per the dictates of Article 27(1) of the Constitution, which provides for equality and freedom from discrimination. And then there is also Article 25(c), which provides for a fair trial as a fundamental right. In my view, the right to be heard is enshrined in the 2010 Constitution. Mr. Morara Omoke, whether the bill violated Article 43(1)(a) of the Constitution in view of the COVID-19 pandemic, whether both or either of the houses of Parliament were infirmed from considering the constitutional amendment bill in view of the Chief Justice's advisory opinion for the dissolution of Parliament, and whether the petitioners had made out a case for disclosure and publication of the BBI Steering Committee's financial information. I've had the advantage of reading the lead judgment by Musinga J.A., the President of the Court, on these issues, and I entirely agree with him. I've made a few comments, but in the interest of time, I will not go through those comments. And on the appeal by the Kenya National Union of Nurses, the 15th respondent herein, the gist of their complaint was that whereas their views had initially been included in the BBI task force, the same did not find its way to the Constitution of Kenya Amendment Bill 2020. They supported the appeal and urged us to find that the amendment process was legal and constitutionally sound, and faulted the High Court for finding that the basic structure doctrine applied in Kenya. As stated above, the 15th respondent's grievance is that their views, whereas their views of having an independent commission were initially captured in the BBI task force, these views were subsequently omitted. In my view, this is a fairly straightforward issue. If the 15th respondent would like an amendment of the 2010 Constitution to have itself included as an independent commission, they can take advantage of the provisions of Article 257 of the Constitution. They cannot ride on an initiative of another and complain that their views have been left out. In any event, the fact that their views were contained in the BBI task force did not create any legitimate expectation on their part. I shall say no more on this issue, save to state that the appeal is devoid of merit and it is accordingly dismissed. Those are my views. Thank you.
Thank you, my sister, Justice Sichale. We will now have my brother, the Honorable Mr. Justice Gatembu, summarize his judgment.
Thank you. Thank you very much, President. I think at the conclusion of the argument, last time we sat here, you told us that when we retire, we can consider your submissions and other material. Now, I think it is my turn to say that when you retire, you can read our judgments in full. So I'll give you just a short synopsis of what I have said in my judgment. So this is what I have said. In this judgment, I only address some of the issues arising from the consolidated appeals. I do so under 6 broad themes. The first is the question of applicability of the basic structure doctrine to Kenya. Second is the question of the scope of popular initiative under Article 257 of the Constitution and the place of public participation in that regard. Under that, there is a question whether it is open to the President to propose or initiate amendment of the Constitution through popular initiative route, and whether the amendment process used in this instance the BBI process is constitutional. The third area I will address is in relation to IBC, its role in the popular initiative process, whether there is adequate legal infrastructure to enable IBC to conduct the referendum under Article 257 of the Constitution, whether IEBC's administrative procedures are adequate to enable it to undertake its verification role, whether it had quorum to conduct business in that regard, and whether it is under a duty to conduct nationwide voter registration before carrying out the referendum. I'll also address under this theme the question of whether a single or multiple questions should be framed for the referendum. The fourth area is in relation to matters concerning the President. Does the President enjoy absolute immunity from civil proceedings under Article 143 of the Constitution? And was his right to fair hearing violated, and was he condemned and heard? And the fifth area I will touch on is on the amicus curiae, whether the High Court was wrong in admitting them in the proceedings. And sixth is the question whether the High Court wrongly exercised jurisdiction in the matter by reason of doctrines of mootness and ripeness, political questions, and constitutional avoidance, and deference to other state organs. So I begin with the basic structure doctrine, and I reproduce there, and I will not read what the High Court said. I then look at the arguments from both sides, and then I say this. In terms of identification of the basic structure in the Constitution, the Court stated that it consists of the foundational structure of the Constitution as provided in the preamble, the 18 chapters, and the 6 schedules of the Constitution, which form the fundamental core structure, values, and principles of the Constitution, which cannot be amended without recalling primary constituent power of the people. This structure, the Court stated, outlines the system of government Kenyans chose, including the design of the judiciary, parliament, the executive, the independent commissions, and other offices, and the devolved system of government, and includes the provisions on land and environment, leadership and integrity, public finance, and national security. I then reproduce there at length what they say. To illustrate the distinction between unamendable and amendable constitutional provisions, the Court cited Article 2(1) of the Constitution, which provides that the Constitution is the supreme law of the Republic and binds all persons and all state organs at both levels of government, as an example of an amendable or eternity clause, which can only be changed through exercise of primary constituent power on the ground that it expresses a core and fundamental principle of the Constitution. In contrast, the Court stated Article 2, sub 5 of the Constitution, which provides that the general rules of international law shall form part of the law of Kenya, is also part of the basic structure, and that the spirit or the core meaning or value of that clause cannot be changed without involving the primary constituent power. It may, however, be amended through the secondary constituent power under Article 255 to clarify its meaning. The other example given is Article 89(1) of the Constitution, which provides that there shall be 290 constituencies, in respect of which the Court expressed that its core meaning and import can only be changed through primary constituent power, but the actual number of constituencies can be increased or reduced through either secondary constituent power or constituted power. I then set out the arguments that have been made on either side on applicability of the doctrine, and then I go on to say as follows. Having considered those arguments, the question whether the High Court correctly determined that the doctrine of basic structure is applicable in Kenya is a difficult one. The arguments advanced by learned counsel on both sides are powerful and most persuasive. The following, however, is the view I take. In his book, Constitutional and Administrative Law, D. Smith argues that although written constitutions differ widely in their purposes, form, and content, they will normally be found to have two characteristics in common. Namely, there will be the fundamental law of the land, and there will be a kind of higher law and the legal source of legitimate authority. A higher kind of law in that the law set out in the Constitution will be hierarchically superior to other laws and will not be alterable except by a specially prescribed procedure for amendment. Chapter 16 of the Constitution, titled Amendment of this Constitution, prescribes the procedure for amendment of the Constitution. Article 255(1) stipulates that a proposed amendment to the Constitution shall be enacted in accordance with Article 256 or 257 and approved in accordance with Clause 2 by a referendum. If the amendment relates to the matters that are set out under that article, which I then reproduce. Article 256 sets out the amendment process through a parliamentary initiative, while 257 sets out the amendment process by popular initiative. On the face of it, those provisions of Chapter 16 of the Constitution would appear clear and unambiguous, and construed in their natural and ordinary sense would mean that every provision in the Constitution is amendable, provided the stipulated process of amendment is followed. However, Article 259 of the Constitution commands that the Constitution shall be interpreted in a manner that promotes its purposes, values, and principles, advances the rule of law and human rights and fundamental freedoms in the Bill of Rights, permits the development of the law, and contributes to good governance. Article 10 of the Constitution commands that in applying or interpreting the Constitution or any law, the national values and principles of governance set out in that article, including the rule of law, democracy, and participation of the people, bind all organs, state officers, and all persons. Earlier, the same principle of constitutional interpretation was expressed by the Court of Appeal in Tanzania in the Dianabo case, and I have reproduced portions of that. I have also cited the Supreme Court decision in the matter of interim independent commission, which expressed that rules of constitutional interpretation do not favor formalistic or positivist approaches, and that every style of constitution compels a broad and flexible approach to interpretation. And I reproduce segments of that judgment there. Given those principles of constitutional interpretation, the High Court was right in the methodology it employed in interpreting the constitutional provisions from a historical and contextual perspective, and the complaint that the court misapprehended the methodology applicable is not well-founded. What then is the doctrine of basic structure, and was the High Court right in holding that it applies in Kenya? In an article for the Center for Public Interest Uganda titled The Basic Structure Doctrine and Constitutional Restraint, take away from age limit decision, Benson Tusariwe writes that the doctrine of basic structure holds that the Constitution has certain basic features which underlie not just the letter, but also the spirit of that Constitution. These features constitute...
What is the basic structure in reference to that Constitution? How does one identify the basic structure of the Constitution so as to come to the conclusion that the intended amendment will alter or change that basic structure, such as to bring the basic structure doctrine into play? The general complaint that has been leveled against the Judgement Court in regard to the finding at paragraph 474F, which I have quoted in my judgment, but which I will now not read. The general complaint is that the foundational structure described by the judges as covering preamble, the 18 chapters, and the 6 schedules of the Constitution essentially means that the basic structure covers the whole Constitution. To use Ugandan Chief Justice Katurebe's illustration, which he gave in the Mabarizi appeal, the description of the High Court would not only include the foundation, the pillars, the walls, and the trusses, but even the roof, the doors, and the windows. A strict interpretation of the basic structure doctrine with this understanding of the basic structure would mean that the basic structure of the Kenya Constitution would literally consist of the whole Constitution. And therefore, it would be saying the whole Constitution can primary constituent power. In my judgment, I have examined what Professor Nobweze says on sovereignty and the exercise of primary constituent power, And I've also looked at the adoption by Ringera J in the Njoya's case of what Professor Nabweze says. And I'm in agreement that the people, in exercise of constituent power, can abrogate their constitution or make a new constitution, and that the exercise of that constituent power demands the participation of the people through civic education, public participation, constituent assembly debate, consultation and public discourse, and finally a referendum in which the people endorse the new constitution or the abrogated constitution. This is the exercise of the primary constituent power as explained by Professor Nabweze, Professor Rosnai, and applied by Justice Ringera. As defined by Professor Rosnai, primary constituent power is distinct from secondary constituent power. The latter is what Ringera J addressed in considering whether Parliament had powers under Section 47 of the former Constitution to make amendments that would result in the repeal or abrogation of the Constitution or the enactment of a new Constitution. In this regard, Ringera J was categorical that Parliament has no such powers. Ringera J concurred with the position in the Casavananda case that Parliament has no power to amend or change the basic features of the Constitution or abrogate and enact a new one. And I'm in agreement with this position, which is the position that was adopted by the learned judges in the High Court. However, it is important to note that Ringera J did not address the exercise of secondary constituent power in regard to an amendment initiated by public initiative, as the Constitution, as it was then, did not provide for it. In my view, the people can exercise their sovereignty in constitution making through their secondary constituent power by either delegating to Parliament or reserving to themselves the power to amend the Constitution. This is what the framers of the Constitution did in Articles 255 to 257 by delegating the power to Parliament to amend the Constitution under Article 256, Subarticle 1 to 5, through a parliamentary initiative and allowing the people to exercise their reserved powers to amend the Constitution through a popular initiative under Article 257. This means that the popular initiative is a citizen-driven process. In both instances, the people remain involved in both the popular initiative and parliamentary initiative through public participation and are the ultimate determinant through the referendum process on whether the amendment is carried. The Constitution of Kenya 2010 also empowers Parliament to exercise constituted power under Article 94(3) of the Constitution in regard to amendment of constitutional provisions other than those mentioned in Article 255. It is necessary to interrogate the express constitutional provisions that donate amendment power so as to determine the extent of the powers provided, especially as relates to the amendment of the basic structure. The starting point for such an interrogation must be an understanding of amendment of the Constitution and a distinction between amendment and dismemberment or change and remaking of a Constitution. In the judgment, I have looked at several definitions of amendment and dismemberment. And from these definitions, it is clear that an amendment is an alteration of the Constitution that is carried out within the confines of the existing Constitution. Secondly, it alters the Constitution in a way that does not radically change the nature of the Constitution, which means it must remain consistent with the object of and the purpose of the Constitution. This is to be contrasted with change or remaking of the Constitution, which involves a complete review and/or substitution of the former Constitution with a new one, and this can only be done through the exercise of primary constituent power. Therefore, dismemberment in regard to Constitution would mean completely tearing the Constitution apart by removing its significant parts so that it no longer has the same identity. This is more drastic than amendment. I bear in mind these definitions and distinctions as I proceed to consider the amendment power. As noted in the judgment of the High Court and the respective submissions that were made before us, the history of Kenya in regard to amendment of the Constitution is replete with abuse of the amendment provisions and a hyper-amendment culture that resulted in the mutilation of the former Constitution. In truth, the amendments culminated in dismemberment of the original Constitution. It is in that context that Chapter 16 of the Constitution was made and must be understood. The framers of the Constitution no doubt wanted to make sure that a situation does not arise where the amendment provisions are abused in a way that results in dismemberment. Dismemberment of the Constitution or negates the spirit and purpose of the Constitution. Nonetheless, they incorporated a specific chapter of the Constitution dealing with amendment of the Constitution, leaving no doubt that they accepted the fact that there will be situations in which there will be need to amend the Constitution. The amendment provisions in Chapter 16 were made with abundant caution, as Article 255 provides not only for amendment of the Constitution to be made either through Parliament or through a popular initiative, but also provides a higher threshold for amendments relating to certain thematic areas of the Constitution. The thematic areas have been identified in Article 255, and I have reproduced them in my judgment. I will not go through them now. But it appears to me that the framers of the Constitution, either consciously or unwittingly, identified the basic structure of our Constitution through Article 255. In my view, the thematic areas that have been identified are crucial and form the pillars of the Constitution. For example, without the thematic areas of the supremacy of the Constitution, the territory of Kenya, and the sovereignty of the people, the document would not have its identity and would be a completely different document from what was envisaged by the people and the framers of the Constitution. Without the national values and principles of governance, the Bill of Rights, and the independence of the judiciary, the Constitution would be a hollow document, not protecting the rights of the people or serving the interests of the people of Kenya as was intended. That is to say that the framers of the Constitution of Kenya 2010, conscious of these thematic areas as the main pillars forming the basic structure of the Constitution, nonetheless provided a leeway for amendment of these thematic areas, putting in place appropriate safeguards, including the people's participation and final decision on the amendments. This is a clear indication that in regard to amendments, the Constitution of Kenya 2010 is explicit and self-sufficient. The key question in considering whether the basic structure doctrine applies in Kenya is whether, notwithstanding the express provisions for constitutional amendment contained in Chapter 16 of the Constitution and the limitations imposed therein, additional implied conditions that limit the amendment power can be inferred relying on the basic structure doctrine, and whether there are any eternity clauses or provisions of the Constitution that are unamendable. As my brother Judge Gatembo stated, the concept of a basic structure is not a new concept in our jurisdiction. Like him, I have also identified a few cases where this concept was discussed by the courts. And from the submissions that were made before us, it is clear that the issue of constitutional amendments is a topical issue that has elicited opinions, debates, and scholarly writings from jurists and academicians. It has also been subject of litigation of constitutional amendments has come to the fore. Like the opinion of doctors, the opinion of legal experts is divided. Some is like, and what should be the aspiration in making the Constitution? But constitutions are like human beings. They are never perfect. Each constitution responds to different circumstances in a social setup that is not necessarily the same as another. Constitutions cannot therefore be the same. Many times, as happened during the constitutional review process in Kenya, compromises and concessions have to be made in order to arrive at an agreement. Furthermore, although the people make the Constitution with assistance from experts, the views of experts, important as they are not always followed. These are all important factors in the interpretation of the Constitution. Amendment of constitutions are often necessary to respond to situations or changing circumstances in the particular society. Likewise, The framers of the Constitution of Kenya 2010 recognized the need for development of the Constitution and provided for it in Article 259. This article obligates an interpretation of the Constitution in a manner that not only promotes its purposes, values, and principles, but also advances the rule of law, the human rights and fundamental freedoms, and permits the development of the law and contributes to good governance. Thus, the Constitution must be interpreted in a balanced way that achieves all these aims. As already noted, Article 255 provides a limitation to the amendment power in the identified thematic areas. It provides a higher threshold for alteration of any part of the basic structure identified in Article 255. Such amendments can only be done within the constitutional boundaries so that the amendment does not distort or deviate from the original purport of the Constitution. Under Article 257, the people can call in their reserved secondary constituent amendment powers through a popular initiative. But the exercise of that power must remain subservient to the Constitution because it is a power that, unlike the primary constituent power, emanates from the Constitution. The amendment must serve the Constitution to the extent of developing it without deviating from its original purport. The amendment must remain faithful to the Constitution. The exercise of the secondary constituent power under Article 257 of the Constitution through an amendment by a popular initiative is not inconsistent with the basic structure doctrine, though slightly different from the application in India, to the extent that the power is expressly provided for in the Constitution, and the amendment initiative neither originates from Parliament nor does Parliament have the final say. The amendment process provided in Article 257 is inclusive, as it not only involves the people in its initial stages, but also provides room for participation of Parliament and the National Assembly, and the people retain the power of approving the final product at the referendum. It is therefore true to the original purport of the Constitution. At paragraph 47G, permit me just to read just a little at all, because they are deemed to express categorical core values. And these provisions are therefore unamendable. These provisions can also be termed as eternity clauses. And then they say an exhaustive list of which specific provisions in the Constitution are unamendable or are eternity clauses is inadvisable to make in vacuum. The learned judges go on to give, but according to Professor Rosnai, unamendable provisions limit the holder of the constitutional amendment power in exercising its power to certain constitutional subjects, principles, or institutions. Professor Rosnai also posits that unamendable provisions may also generally protect the spirit of the Constitution, spirit of the preamble, fundamental structure of the Constitution, or nature and constitutional elements of the state. The Constitution of Kenya has not specifically identified any particular clause as an unamendable clause or an eternity clause. Therefore, as admitted by the learned judges, there are no express eternity clauses or unamendable provisions in the Constitution. However, as already noted, there is restriction of amendment power in Chapter 16 of the Constitution, such that under Article 255 to 257, there are procedural and substantive limitations to the amendment power, so that amendments involving the specific thematic areas can only be done if there is compliance with the strict procedures provided. It cannot be said that the provisions in the thematic areas are unamendable because the Constitution has provided for amendability subject to the limitations indicated in Chapter 16. The question is whether, as contended by the learned judges, there are certain provisions in the Constitution that are inoculated from this amendment power because they express core categorical values. As there is no express provision for unamendability, is there justification that there are unamendable clauses in the Constitution? I find the argument by Professor Rosnai that there may be a general implicit unamendability that runs through the Constitution to protect the original purport and spirit of the Constitution persuasive. This is consistent with the sentiments expressed by the learned judges in in two of the cases that were relied upon by the judges of the High Court, and which I have reproduced in my judgment for purpose of clarity. But I will just mention them here. There was the United Democratic Movement versus Speaker of National Assembly and others, which is a South African case, and which they talk about the preamble to our Constitution is a characteristic, task, but profound recordial of where we come from, what aspirations we espouse, and how we seek to realize them. And then it goes on, but I will not read it. Then similar sentiments were also expressed by the Tanzania Court of Appeal in Dianabo versus the Attorney General, where they said, among other things, that the Constitution of the United Republic of Tanzania is a living instrument, having a soul and a consciousness of its own, as reflected in the preamble and fundamental objectives and directive principles of state policy. In interrogating the original purport and spirit of our Constitution, my first port of call is the preamble to the Constitution, which I have reproduced in my judgment, but I'll not read in the interest of time. The preamble indicates that the Constitution is the exercise of the sovereignty of the people of Kenya in determining their form of governance to meet their aspirations for a government based on the essential values of human rights, equality, freedom, democracy, social justice, and the rule of law. It also shows their commitment to nurturing and protecting the well-being of the individual, the family, communities, and the nation. It also shows the sustainment of their heritage, their commitment to sustainment of their heritage and environment for their benefit and that of future generations, and the fostering of peace and unity as one indivisible sovereign nation. These aspirations and objectives are the purport and spirit of the Constitution that must remain alive in the implementation of the Constitution. The exercise of any legislative power to enact an amendment that is contrary to the purport and spirit of the Constitution will not pass muster. That is to say that although all the core parts of the Constitution are amendable under Chapter 16 of the Constitution, there is an implied limitation that amendment of the Constitution will only be permissible if compliant with the purport and spirit of the Constitution. In this regard, I respectfully disagree with the position taken in the decision in the South African case of KwaZulu-Natal and others versus President of the Republic of South Africa, where it was stated that the reliance upon the spirit of the Constitution is misconceived, and that once the procedure in the amendment process is adhered to, the amendment is constitutionally unassailable. I disagree with that. In my view, any proposed constitutional amendment must pass muster both the procedural, in both the procedural and substantive tests. Accordingly, the fact-intensive determination that was adverted to by the High Court should not be one to determine the unamendability of any particular constitutional clause or core parts of the Constitution, but a substantive examination of the purported amendment in order to determine whether the amendment meets the substantive test in regard to the spirit and purport of the Constitution as revealed in the preamble. This is a